I'll be coming for your love, okay? Take
on
on me. Take me on. I'll be gone in a day or two.
We're live,
So
buddy.
needless to say, I'm odds and ends, but I'll be stumbling anyway. So early life's okay. Say after me. No better be safe than sorry. Take on me.
Yep, we are
Mischief
live.
Manager, do you have any requests? Do you have any requests for your engagement party? I'm here to help. Do you have any requests?
That's what we were doing in the background. We were singing and having some fun. Welcome, everyone. Happy Friday to all of you. Of course, I am Rob. The channel is Law and Lumber. It is Friday Night Frenzy, and it wouldn't be a Friday Night Frenzy without the great uncivil law. Kurt, how you doing, my friend?
I'm in great spirits. I'm feeling great.
I put on a nice fire.
I know. It looks great.
It's cozy.
It looks really, really good. Very fashionable, sir.
Oh, thank you.
So now you're keeping the jury warm. How nice of you.
Oh, God, keeping the jury warm. Oh, no. Oh, we're going to get to that motion.
Chestnuts roasting on an open fire.
Jack
Frost nipping at your nose. Oh, it's been said many times, many ways. Merry Christmas to you.
And Happy Hanukkah to those celebrating.
Yes.
Happy Hanukkah. So, welcome to Friday night. It's Friday night. We survived another week of absolute wildness. And it wouldn't be Friday without recapping some of the crazier stories that we have seen this week.
A lot of pile of stupid this week.
Oh,
some of it reaching new levels of stupid I didn't even really realize were fully possible, to be honest.
A whole lot. And I do see the chat flowing with merry engagement announcements. Thank you. Mischief Manager is in the chat, and she is behind the scenes managing Mischief, and Mischief has been managed. So thank you guys for all of the lovely outpouring of kindness that you have shown this week since that announcement. Kurt knew before all of you. So
he likes me better.
Thank you all. Anyways, we've got a bunch of stuff to cover tonight. We have a pretty cram-packed docket this evening, but I do have a couple of funnier stories, surprise stories that I did not know were happening this week. Kurt, did you know that a judge could sentence you to serve time serving fast food?
I heard that story. I did not realize that was one of the options, but okay.
Well, it's an option when the
strictly
judge gives
speaking, it was
you.
Given as an option to the person, so they didn't have to.
That's true. It was given as an option. I've got some things to catch up on because I do want to get to the actual subs of the stories. My gosh, you guys are so exceedingly generous in the chat.
But it shouldn't be any fast food restaurant though, because given the nature of the punishment, where we're supposed to better understand the needs of the customer, and when they're unreasonable, we really should have picked the restaurant for them. Somewhere that they really get the full message. Maybe a Waffle House, late night shift, or something like that. That's where they missed the opportunity, man.
But they picked the message. Didn't they pick the message? Anyways. I did see that a lot of gifted memberships occurred before I started, and what's weird about StreamYard is they don't star them. So I want to thank Brianna Pickney for becoming a member, Becky for becoming a member, Sally for coming in, becoming a member, Carrie as well, Boppet gifted memberships, Dawn Burke gifted memberships, Ree B was giving congratulations to Rob and Mischief, love and grace to both of us, thank you. Dog Mom, congrats to Rob. Fiona, thank you for gifted memberships. Bliss Lamb, thank you for memberships. Patty, thank you for the congrats. Vez, thanks for the congrats. Best wishes on you and Mischief. So happy for you. Thank you. And then additional chats flowed in. I think I'm caught up to the ones that have been starred in StreamYard because I can see them on the YouTube side, but not on the StreamYard side. StreamYard, I really wish you would fix that. I really wish you would. So, anyways, we've got some wildness, some craziness, and part of it includes a Maya motion. Now, Friday Night Frenzy is not usually the place where we talk about the Take Care of Maya case because of the sensitivity of the topic, but we are going to today because the shenanigans, the chicanery, the absolute madness.
the sanctionable unprofessionalism, if I dare say.
I would say that we're about there. Like, I don't usually go that
the
far.
point where the bar should be thinking about private reprimand territory.
Well, I think the bar has been contacted in this particular instance because
I'm
what
sure.
the hell were they thinking?
Yeah, no, it made me it's like it dirties me as a professional. This arrogant asshole who filed this thing has the gall to call himself a brother in the practice of law. Fuck that noise. Sorry. It's a little early for the cursey words, but it came out.
This demonetization comes to you courtesy of uncivil law.
Yeah.
Oh God. Actually, interesting enough, I got a book delivered to me today. Iron 44, the true story of the deadliest firefighting crash in U.S. history, and it's written by Rick Lavers and Gregory Anderson. And it was actually kindly signed. Rob, thank you for the beautiful pens. Here's a book I wrote, unabridged, I would say so, Greg, about one of my trials. It is nowhere as artful as your pen, but I hope you find it interesting, Greg. I will read it. I don't know when I'm going to read this tome, but that's there. Thanks, Greg, for that. That's awesome. I approached that case as neutral as I could until the chicanery, and I like chicanery because
I think I'm still neutral because I'm judging it based on the filings in court.
yeah,
Right. And so we talk about the difference between prejudice and undue prejudice, because it's undue prejudice when it comes outside court, was is based on you effing around inside it, and the judge doesn't like you anymore. That's due prejudice because you're effing around. So I still think I'm being neutral. I'm judging it on its merits, and I'm not liking them very much. Johns Hopkins could be better lawyers, and then I'd applaud them.
Well,
that doesn't seem likely, but in theory,
this gets to a different level of like dirty feeling. Like
it made me feel very ugly inside.
Yeah, we're going to talk about it though. Melanie Parr with a very generous super chat. Thank you for the super chat. Congratulations on your engagement. Not that I'm surprised. She said yes. By the way, Quebec City is an extremely romantic place. The engagement thing. Oh, look who's joining. Spinny wheel. Hey, bud.
Hey, how you doing?
How was your day that I'm extremely jealous of?
Well, you're probably talking more about yesterday. Today I went and got ice cream and had a seafood boil, which was fantastic. But you're probably thinking,
was the pickle ice cream everything you dreamed of?
It was the flavor of choice was bacon, like maple whiskey bacon thing.
That sounds more promising.
Okay.
It was amazing. So that was Ted Parker's ice cream, and the woman who runs it was like, "I really want to meet you," and then she had a family thing, so she couldn't be there.
Aww.
But yeah, it was really good. So
can I, now that you've joined this stream, can I take a moment to call out something real quick?
Maybe.
I mean, I'm in control a little bit. What's the deal with, where was it?
Are you bringing up a
Mr. Runkle of the Bailey decided that this was the perfect opportunity to celebrate certain announcement with a t-shirt. Pour one out for the thirst. I will not, I'm not going to, bat an eye and say that I didn't. I mean, I bought one. It's funny. I love it. It's really funny. It's really funny. Well played, my friend. Well played.
I thought it was hilarious. So I had to do it just because it was funny. That was, that said, if it makes like actual money as opposed to like, hey, it's made like $8, then I'm going to use that money to buy something for the big day. And it'll be a gift addressed from the thirst.
Oh my God. Well, in that case, what I should probably do, I should probably do is is this, and I should probably put it in the chat so that people can actually see it, see your work of art. And if they so choose, they can partake in some of the hilarity that is Mr. Ian Runkle's misbehavior. There you go. That one's pinned. God.
Rob, when you decided to propose to your now fiance, did you give
Yes.
any thought at all to the chat and their thirst?
I didn't. I honestly, Kurt, if I'm being honest, I was thinking more about what the words I was going to say, and I thought I was being set up with the words I was going to say. You know, we were walking on a beach, and she basically says, "There, you know, we stop and she goes, there's actual dolphins jumping in the water." She goes, "Isn't the ocean really big?" I was like, "Are you baiting me here? Is this like a fish in the sea thing?" She goes, "Think about all the adventures across that ocean." I was like, "Are you baiting me?" So essentially, every plan I would have had got boiled down to like me panicking and going, scratch the back and go, "I need you to pay attention to me." That was what I went with. Those were the artful words that I chose. Can you pay attention to me?
Way to go, Rob.
Mm-hmm.
Apparently
Great.
she did.
Well
And
played.
she liked what she did, and she liked what she was being paying attention to.
It was well played. It was I completely fumbled over every word I would have had. The best laid plans of mice and men. Oh gosh. So that is what it is. I'm glad the information's out. I'm glad you guys have been so kind about all of it. You guys worry about the internet's an interesting place. The internet's going to internet.
Mm-hmm.
And I've been pleasantly surprised that the interneting has been kind in nature and exceedingly welcoming. So
That doesn't sound like the internet at all.
I know. Maybe there's another corner of it I'm just not seeing. I don't mind. I'm, over the moon. I have been for a little bit. So, Ian, how was the shoot?
It was amazing. I got to shoot all the things. So I kind of want a PS90. I'm not allowed a PS90, but I kind of want a PS90.
We can store it here.
Except you'd need permits for the PS90 as well, because that's a full auto toy.
Permits?
So.
I can do permits. Kirk can do permits.
I want him to
permits take time and are inconvenient.
Want all the
they
things.
Require you to tell the ATF things.
Yes, the ATF would be up in your business.
The other thing I want to remind the chat of is that today is another day, yet another day, when you can submit your nomination for Mr. Runkle of the Bailey, Mr. Ian Runkle, for the Gundies. So please, if you have not done so yet, you can submit 1 vote per day per video that he's nominated for. He's being nominated for Video of the Year and the most dapper influencer. And I will say that tie, which is, displayed behind me, is a wonderful tie. I don't know about the country. Well, we have disagreements with some of the things that they decide to do up there, but yeah.
I've also decided that I need like an assistant to come with me on these things, and their entire job is just to recognize people and tell me who they are. Because I get to the point of being like, I know this person, and then I don't get to the point of like my brain actually connecting to who it is. So I may have annoyed several people by like, I know you, but who are you? And then there's somebody huge and like somebody I'm a tremendous fan of. So,
well, and then sometimes they don't know you. And you shared a funny story about that too. One of the creators yeah, I
mean, usually they don't know who I am, but that's fine. Because, I'm much smaller than most of these people. But yeah, most recently CoffeeZilla. Earlier was guys from Ordnance Labs. Various other people.
Ordnance. These are massive channels.
How'd CoffeeZilla get invited to this? Doesn't seem like a shtick.
Just,
Okay.
I don't know. That said, he's a really cool guy. So, yeah, and does amazing content. So, yeah. Also got to meet, all sorts of people doing really interesting things in the firearm sphere. Notably, there's a guy, his handle is unfortunate. It's Suckboy Tony.
Come on.
He picked his handle as a joke, and now he's stuck with it. Now that people have
The channel took off.
Yeah, now that he's got attention, he's got a 3D printed. It's this 50 caliber black powder gun. It's really cool. It's really neat, and I'm just like, I totally want to play with it. So yeah.
So for those of you in the chat interested in how you can vote for Ian, Nightbot's going to be dropping that link in the chat every few minutes, so you can click that, go vote. Please do. Would very much appreciate it. And I do want to call this out because I was informed of this earlier. Henhouse Bath Company, super tired from a bilateral mastectomy on Wednesday, but wanted to pop in line and say congrats to you both. Henhouse Bath Company, it's a fight you're fighting right now, and you gotta know there's a lot of people in your corner pulling for that fight. So keep fighting. Here's to a swift recovery. Beat the hell out of that cancer, and I hope to hear that thing is gone and in remission and never to surface again. So, well, Ian, I've got a funny story to start at the beginning. We've got a funny story to cover at the beginning. Let's do this. Should we do a swoop? We should do a swoop. Swoop. Kurt wasn't ready. Double swoop. Unicorn swoop is best swoop, period. Always. Let's see. The first thing that we're covering this evening. This.
The effery.
No.
As EDB might say.
I'm
going to
hoping
cover
it's the
Okay.
Oh,
We're
that's not the effery.
Well, this is a different version of it. So a woman who threw a bowl of food at a Chipotle worker was sentenced to work 2 months in the fast food job.
I don't like this.
Yep. A woman who threw a bowl of hot food in the face of a Chipotle worker has been sentenced to a month in jail and 2 months working fast food. Videos. Are there videos? There are videos.
Of course there's videos. There's going to be security footage. And
oh, wait.
It's usually someone from the crowd. That's a beautiful thing about cell phones, man.
Here's the video.
Yep.
Hang on, let's watch the video. Can I do audio? Is there audio? There is audio. Can you hear the audio?
Oh,
that's assault, brother.
Assault and battery, baby. Yep. It's illegal. You shouldn't do that on every level, by the way. I seriously doubt whatever the problem was worth that. What exactly is the problem? Did you not get what you want? Can you just be like, oh, you made a mistake. Could I have it done again? Or what exactly is the problem?
I mean, or even if they just took your money and gave you nothing, it's like, oh, I will make a sad face and leave because that's better than month in jail plus.
Yeah.
So that was in Parma, Ohio. So the video of the woman, Ms. Haney, berating a Chipotle worker, Emily Russell, on September 5th, and then throwing food in her face at close range went viral after the incident. 39-year-old mother of 4 pleaded guilty to a misdemeanor assault charge and received the sentence last week in Parma, Ohio Municipal Court. Judge Timothy Gilligan, who in my opinion should receive a judge award, gave her a choice of either serving the 90-day jail sentence or 30-day sentence on top of 60 days working in fast food. Question: do you want to walk in her shoes for 2 months and learn how people should treat people, or do you want to do your jail time? Gilligan asked Haney at the hearing. Haney responds, I'd like to walk in their shoes. Yes, I think I would prefer serving food than serving time in jail.
But I don't like the suggestion that working in fast food is like a punishment, like a criminal punishment.
But if part of it is teaching the individual a lesson of how to engage in the
You're just gonna
struggle,
teach
and
your coworkers a lesson about how much it sucks to work with her.
I mean, it might. You never know. Who knows? The person might have learned something. That's what we hope. Haney's yet to find a job. Gilligan and her attorney told CNN on Wednesday. Her attorney, Mr. O'Malley, said his client had no criminal record before the incident and that she is truly sorry for her actions that day. Let's give her the opportunity to not let this one day define the rest of her life. Internet is going to internet, man. I'm sorry. It's not fortunate. It just is what it is. So Gilligan said Haney will have to have her job approved by the court and will have to work there 20 hours a week. He does not currently have a job. Well, this is employment.
Yeah, there you go. Maybe she could keep the job, and but this 20-hour a week thing is kind of BS. It should be 40 hours a week.
It could be. So he told C.
If you don't have a job, especially, we'll force you to get a job. Strictly speaking, of course, the court isn't forcing her. She could serve the time in jail, so they aren't forcing her to work. It's like, which of the options do you like better? The jail, which I absolutely can force you to do, or the fast food work, which I can't force you to do. But which of these options do you like better?
And this is a judge being really clever, like, because this is someone acquiescing to something the court couldn't force, like saying, I will give you this opportunity, but you have to agree to it. And you have to agree to abide by the terms that I'm giving you this opportunity as, under these conditions. And Gilligan tells CNN, every time you watch the video, it makes you more and more upset. He said, I was thinking, what else can I do rather than just have her sit in jail? Yes, to judges that think this way. Yes.
Just up her community service some more. You gave her 150 hours, didn't you?
Yeah,
give her some more if you want. I don't know.
Just you have her take anger management.
There you go.
Anger management only works if you're willing to listen.
Yeah, working in food service isn't going to help if she's not willing to listen either.
What happens if she gets fired from her job? She go back to jail?
Probably, I don't know if she goes back to jail, but I think it would be a violation of conditions. It's just a question of why. Gilligan, the judge, said it's the first time he's handed down this type of sentence, but it's unfortunately not the first incident of this kind to come before him. I believe that emphatically. He said there was one case a couple of years ago in which a customer who didn't get a cookie and a Happy Meal at McDonald's reached through the drive-through window and started punching the worker. That defendant got 90 days in jail.
Could you have tried, I seem to be missing a cookie. Could I please have the cookie?
Could have. People have bad days. So
when I go to McDonald's and I get chicken McNuggets, more often than not, they seem to forget the sauce, even though I ask for it. And I don't punch them through the window.
You tend to have more bad days if you're stupid. Bad days tend to accumulate if you've got the dumb, and especially if you've got the dumb and the angry together. So I feel like that's really the issue here.
So that's the issue. It's interesting. It's not a slap on the wrist. It's actual punishment. The judge gave the opportunity. I don't hate it.
Now, what do you think the odds are that she goes to apply to that very same Chipotle that she?
Probably slim to none.
Yeah.
Just speaking realistically there.
I think, this might be a hostile work environment. I don't recommend going to that particular Chipotle.
Oh, well, jeez, man. Yeah. Oh my gosh, there's some of these chats that are really nice that I need to catch up on real quick. and these are positive ones. Book Dragon KSC. Rob took your advice to make something or to feel better. Took up writing again after 10 years, and you were right. It was an amazing mental reset.
Cool.
I love that. That is awesome. Kadata Smith, yay. Heart my 1 month. Happy to be a part of the Rob Show. Thank you for that. Nancy Robbins, this is Rob, your whiskey advent calendar shipped. I sent the tracking number to Twitter. Don't think I'm going to make it till the end, as I will be heading to the ER soon. I hope that you have a very successful operation and a very swift recovery. I hope you have a great and safe weekend. You too, Nancy. Congrats again. Thank you. That's really kind for you, or kind of you. And you've been remarkably gracious throughout the past several months. Brandy Peterson, super chat, because I was nominated for a Daisy Award, a registered nurse recognition on the day
for the Johns Hopkins case.
We did. I learned about these through the Hopkins case on the day I found out one of my favorite YouTubers was engaged, celebrating us both today. Congratulations on the nomination. There really are a great deal of phenomenal healthcare workers out there, and they are very, very, very much deserving of all the accolades because they put up with us when we are at our worst, and they put on a bright face and they make our lives a little bit better. So congrats to you. Whiskey 77, major milestone for me today. I was awarded my 3 million Safe Miles Award today. Congratulations. And my company flew me to Hawaii to drive a semi for a few miles, so I can say I've driven a semi on every single state in 3 countries.
That's cool.
What an awesome company. That's so cool. Congratulations. That is really cool. Those are some really positive, awesome things to see. And then we've got Tracy, who we're gonna send good wishes out for. Tracy, watching you guys from my hospital room as I had low back surgery this morning, will be part of the rewatch crew as my pain meds are kicking in. Let the pain meds do the work. Relax, fast recovery. You can't recover when you're in pain. So, Susan Feria, serious question: glass or bottles of wine? I don't know. Bottles? Usually bottles. Is that celebration question? Usually bottles. So that was the first little story. Do we want to cover JHACH?
Sure, why not?
Yes, because I have opinions on that, and I have also 20 minutes before I have to go to
Function.
before I'm going to, hopefully some people from San Antonio will come out and meet me. So I might pop in from there.
Gee, who lives?
That'd be cool.
In San
Bring in
Antonio.
the whole real life chat.
Huh. Who lives in San Antonio? You're in Austin, Kurt. Austin's not too far. You can make the drive.
No, it's about an hour 20. Probably a little less at this time of day.
I mean, I'm awesome, but I don't know that I'm like 3 hours of driving awesome.
I mean, the answer when you're presented with opportunities like that is always yes. So, second supplement. Why are we supplementing our motion? Second supplement to defendant JHACH's motion for a new trial based on juror misconduct, motion for jury interview, motion to open discovery into evidence of juror misconduct, and emergency motion to preserve the evidence.
Why?
Because
why?
I don't know. Defendant JHACH, by and through undersigned counsel, pursuant to these rules, files a second supplement to its motion for new trial based on juror misconduct, motion for yada yada, and all the above. A copy of a note to the court sent by juror number 1 on or about October 12th, 2023, during the trial in the above styled cause, and shortly after excerpts.
Which was 2 months ago.
Yep. Shortly after excerpts of Dr. Sally Smith's deposition testimony were published to the jury, is attached as Exhibit B. Is this bookmarked? It's not bookmarked. Hang on, everyone. Shut your eyes for a second. I'm going to zoom. Here's the Exhibit A. Y'all, will the jury be able to observe Sally Smith as a live witness by Zoom during these proceedings? Are we able to be told, A, as there appears to be probable cause of improper actions by/of Sally Smith in her assigned role at JHACH, has/was she written up or coached? And B, is Sally Smith still performing duties at JHACH? Exhibit A. Scroll. An excerpt from the website of the Simon Wiesenthal Center documenting the appearance of a uniform badge of the Nazi German, I'm going to screw that up, Schustaffel,
Sure.
or the SS is attached as Exhibit B. YouTube, don't hate me. This is a pleading. God.
Oh, YouTube's gonna hate you anyway.
Oh, why is this in here? What is going on?
I'm laughing on the outside because I'm crying so hard on the inside.
The SS lightning bolts is a symbol often used by neo-Yazis and certain types of supremacists. The lightning bolts were part of the uniform of the Yazi SS soldiers. Sometimes the SS lightning bolts are used to show support for hateful beliefs and ideologies. Extremists will sometimes use lightning bolt emojis. You guys realize that, right? If you've ever used a lightning bolt emoji, now you're apparently an extremist to evade detection by moderation systems on social media platforms. This tactic is commonplace. Oh, God.
Don't generally do the double lightning bolt. It's not considered a good move.
No, I would probably say that as well. The tactic is commonplace and extremist.
Although I want
codes,
to do
for
it just out of
example,
spite at this point.
I will
uses to
moderate.
replace
I'll mod you
88.
like timeout.
88 or 2 pool ball emojis to reference blank blank, which is I'm not going to say that out loud on this channel.
And for those of you wondering why 8, because the first letter of each word is H, which is the 8th letter of the alphabet. Hence, 8.
It's yeah.
Wait,
and
wasn't the Crazy Eights also the Crazy Idiots? Wasn't that in the movie Uma Thurman?
Yeah, Kill Bill.
Yeah,
I think so. I think it was 88. Yeah.
Was they all
Yazis? Was that a secret Nazi reference?
Were they all
Japan?
Yahtzee?
I thought
Were
it was
they
Crazy Eights.
Crazy Eights?
No, I think it was something else. I think it was like 80. I think it was 88. Yeah.
Oh, it was Crazy.
It wasn't really 88 over them. Yeah. Yeah.
So you learn something every day. I don't know.
And then for some reason we have a picture of the Nazi eagle, even though it's not relevant to anything.
Oh, it's just because they took the whole page.
I don't know if I need to learn that today.
Yeah.
It will be noted that in Exhibit A, juror number 1 is printed the letter S throughout the note, normally with a curve in the spine, except he printed the S with sharp angles when printing Dr. Sally Smith's name. Sure.
Yeah. So
I will also note
the S's are a little sharp.
That is the only time that he actually prints a capitalized S. So your argument is capital S stupid.
The thing is, they're not suggesting, like, all the coverage has been suggesting that they're claiming he is a Yahtzee, which is not actually what the filing is at all.
Well, he would have to know, right? In order for this to be what he's trying to do, he would have to know that's what that symbol means.
Yes,
which might imply he might have some
heard of World War II.
That's fair, I suppose.
I mean, I should hope most people have enough history to know that particular symbol is not a good one.
I don't know. These days, I think like some of that history is being lost. I honestly do.
Both the second and third times that juror number 1 prints Dr. Sally Smith's name in the letter S is shaped in a manner identical to the symbol of the Yahtzee Schustaffel exhibited in Exhibit B. It's also the only times that he prints the capital letter S in either of those. So, moving on. Printing the
he
first
is Polish.
letter,
That's fair. He would know. Fair enough. He is Polish.
Well, it's more of a reason why.
Yeah. He probably isn't a big fan, if I had to guess.
I was gonna go there. Yeah, I was gonna go there.
If I had to guess, I imagine he's not a strong fan.
Printing the first letter of Dr. Smith's first and last name when the matter makes clear. What? Printing the first letter of Dr. Smith's first and last name in this manner. This is what's quoted in the motion. Makes clear juror number 1's bias and prejudice against Dr. Smith, equating Dr. Smith with a notorious Nazi organization.
That's beyond reading a lot into this. That is so far beyond the pale. If there are not sanctions or actions by the bar, I will be very sad.
I mean, when you look at the image, there's enough there that they can probably avoid sanctions or whatever.
Dude, come on.
So,
I just think it's weak as hell.
Yeah, I don't think so, bud, because here's the thing. The whole makes clear, and right now you have a juror who the judge has explicitly told everyone, admonished the representative parties that you are not allowed to contact. The juror can contact you. They can choose to contact you, but you cannot contact them.
Don't think juror 1's going to be picking up the phone to call you anytime soon. Just guessing.
Now, I've got an important question. They say that this was what day, and what day did they bring their application to?
2 months later. It was 2 months.
So they didn't bring this at the time. At this point, if I'm the judge, I'm like, well, you had your chance when you asked them to be yeeted. You didn't bring this up then.
Yeah.
So now I would like to invite you instead, as an alternate remedy, you can go and F yourself. That's your remedy.
Yeah, it also appears, although we can't say for sure, that they got this idea from the anti-Maya subreddit, they have also acknowledged in their emails that we've seen before. They look to the subreddit to apparently get their legal ideas and stuff like this. And someone in subreddit posted this image, and it's been suggested they got the idea from the Reddit, who they're using as their people to look for every last scrap and morsel of whatever's left.
I don't know that it's a stretch, because this is the Reddit post. I'd look back at what was happening in court around the time juror 1 put the S that way, and lo and behold, the evidence, compare the S in the same day. Here's the thing.
Yeah.
I don't care.
I also don't care.
I don't care because
I don't care.
Let me draw this conclusion, kind of a logical sense. Would someone who happens to be Polish view the testimony that they perceived from Dr. Sally Smith? Now, let's take their argument. Let's just take it for a second here, right? And let's say that S was intentionally drawn, hypothetically speaking. Could they perhaps perceive that the individual testifying was acting in something akin to a fascist state actor?
Mengele, maybe?
Could they perceive that? Like, could they, in the process of formulating their opinions, view this witness based on their life experience as testifying to something that they have an actual recollection of? Okay. Where does that tell me that they have any inability to detach what they heard and reach an impartial or unbiased opinion at the conclusion of the trial?
Yeah.
I'm just like, you brought it too late. Your evidence is too freaking weak. Maybe you should leave the garbage you find on Reddit. Like, I'm just reminded of the scene from Fight Club where he's saying to his boss, maybe you shouldn't bring me every piece of garbage you happen to find. That's what this feels like.
And I also go back to the whole thing where you're allowed this little process called voir dire, where you can ask questions of the juror to determine whether they might have life experience that would make them view testimony in your case in one light or another. You can understand what their life experience is. And if you believe that this juror might view the testimony being elicited by your witness in an unfavorable manner, you're allowed this lovely thing that we call peremptory strike, where you can just say you are off the jury without the need to explain cause.
Exactly. And as
And
I
the-
noted in my earlier stream, it's not illegal for someone with Nazi sympathies to serve on a jury.
Yeah, it's not.
So
Or someone who has a great disdain for
yeah,
the SS
yeah,
to
yeah.
serve on the jury.
Those are legal things.
They are.
It is legal in America to be pro-Nazi. It's legal to be anti-Nazi.
You're allowed to do that.
These are
and you're allowed
valid
to sit on a
choices
jury.
in your life.
And it's up to the attorneys that are doing that thing that we call voir dire, of examining the prospective jurors beforehand to elicit testimony from those jurors that might suggest one way or the other. So, in addition, juror number 1 on October 10th of 2023 printed Exhibit C, in which he effectively, oh my gosh, let's look at Exhibit C.
Prejudice the relationship.
Before I read the remaining part of that.
Yeah.
You received a formal request from Dr. S. Smith of JHACH for your records about Maya, correct? So, hey, he's reached the conclusion. Dr. Smith is of JHACH. He's a bad juror. You stated you made a call to S. Smith. Did they send you copies to Smith? Yeah. So the juror apparently is of the apparent opinion that Smith is of JHACH, and they're like, that's not true. We dispute that. I can't think that. Also, I'm surprised they didn't mention that in Exhibit C, there are no sharp S's. You know, it's like, well, if you clearly look at it in this note, look at those S's. Those aren't sharp, so the only way these could be sharp must be because Nazis.
So he printed in which he effectively prejudged relationship between Sally Smith, between defendant and Dr. Smith, equating one with the other. Huh? Of JHACH. Oh, the of JHACH? The of
Yeah,
JHACH?
That's what they're
That's
going
what
with.
you're.
Yeah.
Are you
Yeah.
serious?
Yeah, that's what they're saying.
Maybe because that was in opening arguments. Are
Hmm.
you kidding? Juror number 1's reference to Dr. Sally Smith was the use of Nazi symbolism demonstrates a clear bias, prejudice, and prejudgment against her, and thus defendant in the above styled cause, and demonstrates an additional basis upon which defendant's motion for new trial based on juror misconduct, blah, 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 as well as new trial generally should be granted. I don't know what Kool-Aid you're drinking. I really don't. And I don't know what's in it, but maybe...
How cursey word can I be right now?
You know what? Let her rip.
Yeah, so this guy's an absolute fuckwit, waste of space. And the fact that he considers himself a lawyer and associates himself with me however indirectly, he's a loser, piece of trash, and fucktard who shouldn't have a law license.
These are the opinions of uncivil law. And I say opinions because I can see exactly how he reaches those opinions.
These are the opinions of uncivil law. I don't share them. I will use even greater emphasis.
What the hell? You know, we make comments about, people have made comments about how the plaintiffs are watching some of the recaps, and they've made comments themselves, plaintiffs' counsel. There are certain things that you can watch and perceive from a chat, right? When a legal commentator, someone who happens to be a practicing trial lawyer, is giving commentary on what's happening in a trial, and the chat is responding to that commentary. And you might say, huh, that's interesting thought. Sure. And you might change how you would do something or not. There are places on the internet to find that type of analysis. And, you know, I dare say advice. I don't think I ever did that, but I dare say advice, suggestion. But Reddit isn't one of them, by and large.
Reddit is not known for great legal advice, I have to say. Like, even the subreddits like r/lawyers, it's please, in all the name that's holy, do not go to Reddit for legal advice. I beg of you.
In fact, if you see something on Reddit that looks like legal advice, it's probably wrong, especially if it's a subreddit called r/legal advice. That subreddit is pretty much the opposite of knowledge. It's, so far as I can tell, run by people, and I want to be fair to them, who are at best idiots and at most malicious. And I suspect
So I'm going with idiots.
Hybrid of the two.
The other curious thing about this particular supplement to their original motion, filed several days / weeks after their original motion, and just, what do we now? The order's being entered on the 15th.
Yeah.
Something
I want
about
the judge to physically come off the bench and beat them to death, like the caning of Smith in the Senate.
He
That'd
won't.
be good.
He won't, but and properly so. But what are you?
We need to dispense some justice old school.
This is, and one can infer from the filing of this supplement that they didn't take kindly to the response that was received on the internet to their original motion. And
they thought this would help?
Well, they kept on throwing inflammatory language out there, because one of the things that I think they're counting on is for juror number 1 to be so gaslit by this that juror number 1 makes public statements. And then they can appear in front of Judge Carroll and say, look, Judge, look at these public statements denying our accusations. We now have the right to depose him under oath and say and ask him whether they are true or not. And wouldn't it be great if you gave us discovery into his phone, into his personal life, and we can go digging and finding information, because look, he put himself out there publicly.
Yeah, don't take the bait, juror 1. Don't take the bait.
What a shit show. I cannot believe that was written by an attorney barred in the state of Florida.
Yeah. Our attorney anywhere. Anywhere is so far beyond the pale. It is such a absolute. I cannot imagine. I cannot imagine any set of circumstances in which I would file this motion, particularly on they wrote their S's slightly weird. Like, there is a line of zealous advocacy, but I feel like we went well past that, and I don't like it. Would you ever file this motion?
You got to be kidding me. I wouldn't go anywhere near this. I wouldn't even joke about this in an office setting. I wouldn't. None. Nowhere close to this. I'm dumbfounded. I am honestly, like, I'm sitting here without words. I am dumbfounded at this conduct.
And like, it's truly hard to believe, because these are supposed to be fairly prestigious law firms, a big law, don't you know, that they would file that original motion for juror 1 because he might live with his wife. It's possible. Rob, are you planning on living with your wife? Are you potentially joining this dangerous club?
Oh, the dangerous club that exists between married couples where they live under the same roof, and they have a healthy marital relationship where they both establish boundaries between one another, but they share a life together, and they have healthy dialogue and communication when it's appropriate. And when they're instructed not to have that communication, they don't have that communication because they abide by the rules of a judge. Well, I mean, yeah, I would say that that's a way of.
Rob plans on sullying himself the same way juror 1 did. Wow, what a creep. Yeah, so they have to know. They're too well practiced. They have to know it's absolute bullshit. And I'd like to remind everyone that there's like things about not filing frivolous stuff in court. Right? So you have duty of zealousness to your client, but there are also duties to the court, like not filing frivolous crap, and duty of candor to the tribunal, and other things like that. And so it's like they have to know. How can they not know? How broken is their law firm if they don't know? Right? So it must be that they know.
Well,
They're filing frivolous, inflammatory crap, and they're doing it anyway. Hence, I think the bar should get involved because they're obviously doing it deliberately.
I'm not actually disagreeing with you on this one. At this point in time, I think this is conduct that is very clearly sanctionable and beneath the practice of law. I mean, I made the comment when they
8.4
filed
brings the
first
brings the
motion.
profession into disrepute. Yeah,
Is that where it is? 8.4. I'm
Among
I'm
other
looking at the
things.
rules right now.
I think it's 8.4.
That's what I was doing. I was looking at the rules.
Yeah. Yeah, 8.4. 8.4, it's a professional misconduct to, among other things, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, or D, engage in conduct that's prejudicial to the administration of justice, or commit a criminal act that reflects adversely on honesty. So,
Engage in conduct involving dishonesty or misrepresentation.
Yeah. So, yeah, and it violates some other rules as well. It violates.
How about this one? Engage in conduct in connection with the practice of law that is prejudicial to the administration of justice.
That's what I said. Yeah, exactly.
Yeah, that one.
Yeah.
Oh, national
Yeah.
origins in there too.
Yeah. You're talking about the last one? The 8.4, like H or I or whatever it is?
I'm looking at all of these, man. This is
The last one has not been widely adopted. In fact, I think it's it hasn't been widely adopted.
I mean,
So,
this is just like you said, it's beyond the pale.
yeah.
I need 1 second. Please continue to bash JHACH. I will not be mad if you use profanity.
Okay. Yeah. So I mean, like, lawyers have ethical responsibilities, and at least I take them seriously. That, we're supposed to uphold principles of like justice and the rule of law. It's something I actually believe in. I actually believe in the Constitution. I believe in the rule of law. I believe in the legal system. For all of its many flaws, it's still the best system anyone has ever designed in the history of humanity. So I have a lot of reverence to it, and I don't like seeing it treated like trash. It makes me very angry. I'm very mad.
I mean, I think that they may just be able to string enough together to avoid sanctions. That's
in
as
combination
generous
with
as I
the
can
prior
be
stuff,
about that.
though.
That's as
Like-
generous as I can be about that. I think it's BS. If
3.1, a lawyer shall not bring or defend a proceeding unless there's a basis in fact and law for doing so that's not frivolous.
Well, and here's the other. I want to draw a distinction because someone's going to go out there and make something about like lawyers are different when they're in pleadings and before a court or a tribunal than when they are in public. If Howard Hunter wants to go out in public and make these statements, that's on him. I hope that, as we as humans all make stupid statements from time to time, I hope that we grow from them, learn from them, apologize, and move forward. But there's a very big difference between making a statement in public under your personal capacity than it is to put it in a pleading that you sign as an officer of the court and present to the court in a public filing. Very, very different things. Lawyers are allowed, they have a First Amendment right to talk and communicate and express opinions and express disagreement. They can opine on the juror all they want in public. That's their First Amendment right. It's different when you put that opinion in a legal filing that is supposed to have a substantial basis in law and fact, and you present that to a court as a basis for the relief you're seeking. They're very different. I have said very stupid things from time to time. You will find that I have, well, one, I try to learn from it and move forward and correct myself. But two, I don't put that in pleadings. I don't make those arguments to a court. There's a distinction.
Yep.
So juror number 1, do not take this bait, because that's exactly what it is. And
Yeah,
honestly, the
it's
fact that
totally
this is
bait.
bait, and the fact that this is bait, and the fact that this is being filed this way, very clearly as bait, means that it is filed for an improper purpose.
There you go. Yeah, that's a violation of the rules of ethics. I want a private reprimand, bare minimum on this. I won't get it, but I really want it.
I want the most fire responsive pleading ever. Like, I want a scorched earth pleading in response to this. You know, if you ever had an open door, to basically say all the things that you wanted to say, JHACH just kicked it wide open again.
If you can find them using any S's in that style, I would love that so much. That'd be great.
So, deep breaths, calming happiness, thoughts of things that are not this motion, screaming unicorn.
There's not enough screaming unicorn for this.
There's not. I can't. Very rarely.
It's like it is JHACH and their lawyers just simply evil. I mean,
think they're
because
just grasping for any straw, and like however thin, they're inventing an issue here. And yeah,
Ian, I don't mean to hold you up. I know you had said 20 minutes, and that was more than 20 minutes ago. Do you need to jump?
I've been told that everyone is running late, so I will probably hang out for like 5 more minutes unless somebody messages me and is like, "Hey, where the hell are you?" But yeah, this one just, it makes me upset because I think it's complete horsepucky, but I think that they can, like, I think that they're going to be able to be like, well, this is our theory. And my prediction is they get yelled at, but they don't actually get sanctions. I may be wrong
and
on
his
that.
last super chat's pretty good. Doesn't this exasperate safety issues for Juror 1 and his wife, since they already doxed him and gave away his address, and now the news is calling him a Nazi because of what JHACH wrote. So,
and that's the weird
aren't
thing.
they conscious of the fact that they're putting the juror at actual risk?
That's the actual opposite of their argument. Like, the news has got, oh, we just lost Rob. The news has got this way wrong, because that's actually the opposite of the argument, which is this guy hates Nazis, but compares her to a Nazi.
Yeah, well, surprise, surprise, the news media didn't pick up on that distinction.
Yeah, no, they did not at all, because, like, news media is super lazy.
And I didn't even notice that I had doxed unintentionally Juror 1 because I don't typically read footnotes. It's not my standard practice, because usually footnotes are just kind of meaningless citations. I don't normally read them. So I didn't even notice then the footnote for the motion I had for the 8 days it sat out there and that I covered on stream, that his address was exposed in the document. So I felt a little dirty because JHACH caused me, from their negligence, to put this further in the open. So that didn't make me feel warm and fuzzy also out inside.
I mean, they're panicking. If this is what they're filing, it just tells you they got so little.
Uh-oh. I think,
because if you had any other argument, you'd put that instead.
Pickle cleanse. Yeah, we can do pickle cleanse. Yeah. Yeah. Yeah, thank you, Hipper Luffer, for saying I'm fine. And EDB says footnotes are very important and informative. I don't fault another lawyer for has a different practice. Obviously, if I was doing it in court as in a formal proceeding, I'd obviously read the footnotes. But for just coverage, I just normally like they're throwaways. And so, anyways, that's just how I do it. EDB might do it differently. We're different people. Big surprise. So, yeah. All right, what else can we talk about while Rob desperately tries to rejoin the chat before Uncivil Law just takes over the show? I could read some of his super chats, although I can't bring them up screen. That's a good way to bring time. Mischief Manager, are you behind the scenes? Can you bring them up to the scene? Or Ian, can you bring them up so I can read some of them? I can help that way. There we go. Pants, who's been a member for 13 months, says maybe the filing is forged on their letterhead. I don't think so. No. What else? J. Michael RN says Happy Hanukkah. Happy Hanukkah to everyone else out there. Next.
Sorry, I gotta do this on my phone, so it's pretty rough.
Remen Man YYC says $5 Canadian. If you read a book in Candlelight Pentagram, you summon the JHACH JFench attorney. I believe it. I believe it. Mr. Manager says she can do it easier, so let her do it for now on.
I'll let Mischief Manager handle it.
Okay. Dog Mom gifted 5 gift memberships. Thank you very much for the gift memberships. They always help. Apple Jam PB says the band Kiss also stylizes their S's the same way. That'll be funny if Maya's team brings it up. They restyled the logo for Germany. Maybe Dr. Smith just reminded Juror 1 of 70s glam rock. That's cute. Thank you for the super chat. Don Burke gave $4.99 to say our fathers will be rolling over in their graves. This is not what they want for our country. No, they want actually people to behave in a professional way and be, the very best of us. And this is not it. Next, please. Nancy Robbins 499 says the complaint for response literally be I have no response. I suppose it could be, but I sort of approve of the idea of beating them to death on the page. That'd be good. Welcome back, Rob.
If JHACH was mad about me talking about their motion, they didn't have to just completely firebomb my computer. What the heck? Hang on, that's better. So, yeah, there goes all the links I had pulled up and everything because blue screen of death.
I hate it when that happens. Do you want me to read some more super chats while you reconstruct it?
While I reconstruct all of the behind the scenes and all of the links that were pulled up. And
I got you covered. I got you covered. While Rob reconstructs reality, I'll continue to read some super chats. Mischief Manager, if you would, please. Lindsay says for $5, so if citing the Magna Carta also automatically loses your argument, what does bringing up the Yahtzees result in? Me beating you to death on the legal page. Thank you for the comment. Giraffe Gal 499 says, does this exacerbate safety issues? Yep. Not that JHACH seems to care. Mary Coppola for $9.99 says, I thought jurors' questions and notes were destroyed after the verdict. Their private notes were destroyed. The ones they privately kept for their own reference, not the ones submitted to the court, because those were read in court and are part of the official court proceedings. This is bull ass, accusing someone of the most egregious acts in history. They deserve a reprimand. I tend to agree with you. Thank you for the super chat. A nice icon for your avatar, by the way. That's cool with the eagle. That's kick ass. Kathy Trout for $5 says the chat is worried about Ian. Ian, you all right?
50-50. I'm doing pretty good.
Okay, the chat loves you. The chat loves you, Ian.
I'm just
Jack Edwards says, what is Runkle thinking? Trash fire, I'm pretty sure.
Trash fire, I'm thinking they should be sanctioned. I think they may be able to string an argument together to not be.
Probably.
But this is the kind of thing I would teach in law, show in law school as don't do this.
Yep. Golden Rose Tuxedo for $10 says, there's the slightest possibility Hunter actually won Maya to win and is covering his tracks by filling the absurdities. If this is no, I'm just going to say flat out no. I'm going with no. No. Wendy W says, how could Hunter think this helps JS image? Yeah, JHACH doesn't seem to care because the only reason that we're here is because the attorneys for JHACH have been escalating. And I'm going to assume at no point JHACH said, hey, attorneys, you're kind of making us look bad. So apparently JHACH doesn't seem to mind, which says something about JHACH too, incidentally. But thank you for the super chat. Next meme. Katie at Oz says, what do they gain by doing this? I don't know. Maybe they're trying to, the best possible interpretation is they're just going for every possible thread to make their insurance carrier happy that they tried literally everything. But dude, no, I'm not even giving them that much. Thank you for the chat. Vez from Quebec for $5 Canadian says JHACH lawyers will be sentenced to 2 months working at McDonald's. That sounds about pretty good. Thank you for the chat. The Chugi Show Live 499 says Santa isn't giving these lawyers coal from Xmas. He's going to send them to work the mine and dig up the coal themselves. Preach it. Autumn Blaze 78 $10. JHACH filed this on the first day of Hanukkah and on December 7th, Pearl Harbor. I'm not sure they had that particularly in mind, but it is well noted. The level of violence just beyond utterly disgusting. Also, congrats, Rob. Yay! Marcel, for member for 11 months, says, Howard Hunter, HH. Very good. Very good. Well spotted. I approve. On a Blaze 78 says, well, we read that one. Next, please. There we go. Mama K Bear says, member for 3 months. How could they have thought this would help? Yikes. Yeah, I tend to agree. 20th Century Fox 499 says, I went to Robert E. Lee High School in 1988. Please don't cancel me. I still aspire to be picked for a jury, but maybe not if either party is JHACH. Yeah, I mean, this is going to, among other things, one would imagine those who are paying attention might be somewhat disinclined to serve in a jury in the future because they might be afraid of this happening to them. So among other things, they are poisoning the well for future jurors. So how about that for disciplinary action? Thank you for your super chat. Shiraz 999 says, was the whole point to get all these YouTube lawyers demonetized? YouTube allows a little bit of cursing. They tend to not like it like in the first 2 minutes or stuff, but as long as it's not flagrant, it doesn't usually get to be a problem. So hopefully it won't be a problem for Rob. Hey, but your super chats help.
At this point, I should probably bow out and head over. I'm hoping that the people who are late aren't too late, but if they are, I'll just sip a drink and chill. But cool. I may pop on from in the bar.
Yeah.
So
that would be most enjoyable.
I'm hoping I can pop on and be like, hey, here are some fans.
Headphones. Just like bring a set of headphones, plug into your phone.
I can't.
Dang it. Okay. Either way.
And if there's other fans there, they'd want to hear too, right?
That's true.
Yeah.
That's true.
So I don't have headphones that plug into this phone.
Well,
right. Well, take care of yourself, Ian.
Will do. And if no one shows up, I can pop back up here anyway.
Don't do anything I wouldn't do.
Yeah.
Leaves open a wide possibility of things.
Anyway, I'll see you guys in a bit.
See you, buddy.
Hikara's G for $10 says, I think the S looks like a lightning bolt, and hence he's a Harry Potter fan. And hence he's biased for kids without moms, and hence he is biased and sarcasm. Very nice. I like that very much. Thank you very much for the super chat. Pamela Weisenbach for $5 says, could it be JHACH told lawyers fix this loss or find new improvement? I wouldn't imagine they would have any problem finding improvement. They're a big law, right? So I don't, and also no one needs a client that bad. And if you do, you've really put yourself in the wrong place. But thank you for the super chat. Gamer Ducko says for 15, whatever. Are we the baddies? Some JHACH attorney, probably. Thank you very much. Maya P-Bobia for $2 says, be so disappointed if the judge doesn't sanction defense. He hasn't done it this far, neither of any other judges who have worked on this case, so I wouldn't get your hopes up. It makes me sad, too. Carla Vieira for $4.99 says, Judge Carl should just bar an ID and sanction H. Hunter to serve in jury duty. I don't think that was work. Do you really want this guy on a jury? Seriously? This guy? Come on. He's obviously unfit to serve. Damn. Thank you for the super chat. Sam BD, lying about victims Hunter seems to be normal. If you look at Maya's dependency hearings, he's a terrible lawyer. Well, strictly speaking, he's more of a terrible person because he has lost all humanity. The core of his human essence apparently has been stripped from him because he goes into dependency hearings and goes into court with absolutely no moral compass whatsoever. He might literally be like just a sociopath devoid of emotions. It's, psychopathy is not that uncommon. Well, in grand scheme, it's like something like 1% of the population. So it could just be a person who literally has no feelings. And there are a lot of people like that in high performing jobs, doctors and lawyers. So it just might literally be he's unable to have any empathy or sympathy. So that's a strong possibility. Thank you. Teresa Mora for 499 said, Rob, Melina Little actually allied showed the Reddit thread where Hunter pulled it from last night. She was so mad. We looked at the thread. It's quite possible he's getting his ideas from Reddit, which is never a great move, but thank you for the super chat. Gina Hampton Dukes for $5 says, about JHACH, does political affiliation matter during a civil trial? Typically not, unless there's particularly sensitive political issues, so it wouldn't normally be relevant. Were other jurors questions? Yes, to the extent that the council wanted to. This seems like bigotry by JHACH to me. Fair. Cynic in Chief for $5 says, the latest filing is a troll by a Redditor realizing they can feed JHACH a bunch of nonsense. I'll file it. I'll salute them. If this winds up being someone who's just incredibly pro Maya, who has somehow figured out how to troll Maya, the JHACH lawyers, then bravo to whoever that is at Reddit. If that is what's going on, I salute you, sir, because they apparently fell for your bait somehow. Thank you for the super chat. Rain Man YYC for $5 Canadian says, if you read the book in a pentagram, you summon JHACH. That sounds about right. Thank you for the super chat. Crazy Cat Queen SSFU Hunter for $2 says, anyone else wonder who hurt Hunter a long time ago? He seems somewhat burned out inside, but he could become a better man. So yeah, next super chat, please. Crazy Cat Queen SFFU Hunter for $2 said, just wanted to show off my new name. We appreciate it.
Indeed.
Are you ready to go on, or should I keep reading?
I think I've got it. So, Mischief, if you can see the other ones that are JHACH related and pull those up, Kurt and I would be happy to respond to them. I can't see them because so for those of you who are concerned about the computer, etc., what you don't really realize is that a lot of RAM gets used when you are live streaming through web browsers. And I don't know what happened, but something overheated the computer. I got to get one of these fancy gaming computers like Attorney Diaz had in the back of that courtroom. Do you see the Alienware computer he had back there?
We could build you a computer, Rob. We could build you a computer. We could do a build together. That'd be a build. Yeah, I come over to your house. We can order the parts and we'll build something together. We'll build a computer.
See, make something, we'll feel better. I will feel better knowing that my computer's not going to crash in the middle of a live stream. Oh,
yeah.
It is
wild. I'll help you out.
What happens. And yes, it does happen to me quite a bit. I also happen to do a show that covers a lot of topics where I have a ton of tabs pulled open. So that's also part of it. So,
well, if you're using Chrome is particularly memory hungry for some reason. So I would probably use Firefox. I switched to Firefox and I don't have as many problems.
Yeah. See, David's coming in with computer advice, which is very apropos. 32 gigabytes of RAM minimum. Oh, baby. I have some to go before I get there. I think I've got 16 running, and it, for normal function, that's plenty. For the streaming stuff, not so much. I'm going to take David.
Yeah, I've got 64. And even then I was like, my computer could do twice as much. So yeah.
Golly, man, it is wild. Oh, it's a little bit frustrating because I don't like leaving you guys in a lurch. I don't like that. It's not fun.
That's okay. The chat and I were having fun. Isn't that right, chat?
Chat did great. Chat did great. Y'all did great. So the first chat. So this is to Mischief. The first chat I see is this lovely chat from Angel Baby 4210, and then the follow up from Hippo Lover, who's in the chat as we're talking about what
Don't
I am
fall for the
being-
Bait.
What
Don't
I am
either of
being
you fall for the
told
bait. Keep your mouth
is-
shut.
I'm being told that the subject of the motion is the lovely husband of Hippo Lover. Oh, there we go. And I'm being told,
Don't take the bait.
I'm told that this avatar is in fact the juror number one. And
It
that
is.
It is
It is.
terrible that juror number one is appearing on these live streams or making their presence known in the chat, because my gosh, people aren't allowed to have opinions after they sat on a jury, and they're not allowed to be husband and wife and not
Or
talk
live
about a
together.
case.
They
Or
live together, don't you know?
Well,
As many times as they wanted to remind me. How many times did they mention they lived together in that motion? It was a lot. That's why I keep making the joke, because they mentioned it so much.
because they live together. Because
Yeah.
they live together. They have not hired the services of one divorce attorney because they live together in a functional, happy marriage.
I thought husbands and wives, if they had a happy marriage, were supposed to live in different homes.
It wasn't too long ago that husbands and wives used to have separate bedrooms or separate beds within the same room. Just I don't know. This is barking up the wrong tree, and it is getting to a place where I am.
Rob's mad. Rob has lost the ability to have words, because I also lost the ability to have words because, yeah, I have the same problem, Rob. Yeah.
This doesn't happen to me. Usually I can, even when I'm upset, I can usually speak about it more. I'm just lost.
This is a whole new level, all right? Yeah.
This is an attack.
Yeah.
And it's a disgusting attack. You know what? I want to do here.
So.
I want to do this. We're going to do let's do this one. Since Emily was mentioned earlier.
1 second. I'm looking for a pill. I'll be right back.
You do that. We have the old one.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
And we have the new one. Oh, there we go. What's the pillow say? Some days the supply of available swear words is insufficient to meet my demands. Kurt, I have to share something with you that is at my office. But one, I love the pillow. Two, one of the lovely channel viewers sent me, and I can't recall the name. It's written on the actual jar. They sent me a jar of laser cutout pucks, like in like little laser cutouts. Jar of how many of these Fs I had to give. Sitting on my desk, a little jar.
Look at my field of Fs. It is follow. Yeah.
And what I have decided that I want to do is when I have a client or opposing counsel who's being sufficiently irritating, I'm going to pour out all of those Fs in my drawer, and I'm going to have the jar, and I'm going to put one of them back in, and I will display the jar, and I will pull that last F out of the jar and just toss it and be like, that was my last one. I don't have any more to give. So a bit theatrical, but I think appropriate.
Yeah. Yeah.
Oh, and I'm seeing the chat. I know that Peter was gobsmacked by this. So K-Rab, I you know why I know Peter was gobsmacked by this? Because I texted him the motion. I texted him the motion, and I was like, read this. And he texted me back things I'm not going to share because I don't do that. But
could you give us a flavor?
The flavor is
scene.
The flavor and the scene is one of disbelief and one of what's going on. Like, is this the way you want to go out? Right? Is this the the horse you want to tie your wagon to.
Mm.
Why? You arguably, a lot of the lawyers in that firm have a career in front of them.
Mm.
Is this the motion you want brought up over and over
Mm.
and over again for the duration of your career?
Yep.
Like, this video is going to live on the internet forever. Hopefully. Do you really want the puzzled face of two lawyers who are at a loss for words for what you filed? And do you want my fear? Here's my fear. We're going to see a third supplement like on Tuesday or something like that.
Put this in your supplement.
I went to bat for Hunter early in this trial coverage because I thought he was arguing the position he had to argue. I thought he was doing a decent job, and to see the frazzling or the untangling, like, right, just to see it fall apart in front of you, going, what is happening? There were cogent arguments being made, and then all of a sudden you've got this. You're going, what is happening?
I think, as I've said on my own streams, I think, given my understanding of the history of this case with the 3 different judges who have presided over it, based on my limited understanding, so perhaps it's not completely correct, but you guys have been talking to me about like these 15 motions for iCloud data. And as I was telling Rob, like, it should theoretically take one. You know, you should have one, and then you do it, or you say, and then if you don't do it, the next thing is contempt, order to show cause, and the whacking stick. Now, as Rob pointed out when I talked to him about that isn't necessarily the way the world always works, which I understand that, but they had 15 motions on the iCloud data, 15 to get it, and the IJ report has still never been produced, despite all the court orders. And much like children, you can't make threats that you're not prepared to follow through with. And courts must enforce their orders, or else they're meaningless. And I think at least some of this, because JHACH had underlying shittiness, and their lawyers obviously had underlying shittiness, that much is apparent, because you don't get this shitty unless you had some underlying shittiness. Because even in my shittiest day, I couldn't imagine doing this. That's why I say that. But even though they had some underlying shittiness, I think at least in part, the reason we are where we are is because none of the judges took them to the woodshed. They never were willing to actually enforce their orders. There should have been orders to pay money, and probably, given like 15 motions is so ridiculous, I would have thought there would have been it was 15 hearings, 35 motions. So yeah, so that's what I'm saying, right? It's 15 hearings, 35 motions. This is absolutely absurd. Like, if I were the judge, I would have ordered default long ago. Because how about you just lose your civil case? How about you're just done? You don't get to offer in a defense. You just lose.
Well, may I also remind the chat that this is the same attorney. The attorney that filed this motion is the same attorney who made the statement in court that, Your Honor, this argument has more landmines than the beaches at Normandy. So
not a great comparison. Not a great
thing. Now, what I want to here's the caveat. Here's what I want to explain, because there is, Kurt, I do a lot of trial work, and because of that, I see a lot of things in court that leads me to the ability to explain things that aren't the world, to explain things that the world the way it is and not the way it should be. And to try,
I have the manual. The manual tells me what to do. Why not just follow the manual?
Exactly. But and my job on the internet, and what I'm trying to do here, is explain why this situation kind of gets to this place, and to acknowledge it's not the best thing. We don't want it to be that. We're trying to fix it, but to explain how we get here. One of the things is that certain attorneys, the longer you practice, the reputation that goes with you and the firm that you're with, right? The large firm, the big dollars, the big clients, you build a reputation where, let's say you've got a credibility jar, and
Yeah.
the longer you practice, the more that you put little chits in the credibility jar.
Sure.
And every now and then you run into a hiccup and a couple of those chits come out of the credibility jar. But by the time you get to Howard Hunter and how long he's been practicing and the clients that he's had, the firm he's with, you have a pretty substantial jar, right? The jar is pretty full. And at that point in time, judges are very willing to give the benefit of the doubt, even within, it
This
goes
much.
both ways.
35
goes both
motions,
ways.
15 hearings.
It goes both ways, right? There's lawyers that are very young. So the judge gives the benefit of the doubt to the lawyer that's very young. The judge gives the benefit of the doubt to the lawyer that's been practicing a long time. And in certain cases, that can become pervasive in the pleadings. I have represented a client in front of an attorney of this type, and I was astounded by what this attorney could put into motions and still somehow convince the court. I couldn't believe it. I think I've talked about the attorney, and I've referred to that attorney as being 1 foot in the unethical side, 1 foot on the ethical side with every motion, and just one step, one step, one step, one step. Right. And it was impossible to explain and get the judge to see things my way because of the weight that that attorney somehow had built up, whether it's fear, gravitas, whatever you want to call it, right? Political power, pull, strength, intimidation, call it what you want to call it. It's a personal thing. It's a thing that you experience, and judges are not immune from it. So when
I understand that to a degree. I get it. I understand it to a degree. Like you have a good reputation, so I'm going to cut you a little slack. But like, dude, come on. Like,
and that's the point that we started to reach during the trial, which was really interesting. And I've talked to Greg Anderson about this. I talked to him personally about this, and Nick Whitney too. Nick Whitney, the younger attorney, Greg Anderson, the mentor, and Nick would struggle to wrap his head around this, but Greg kind of understood it, how it felt like at the beginning of this trial or at the beginning of the case throughout discovery, that there was always a thumb on the scale because it was going up against a giant. And the giant has leverage, and it's very difficult. And trying to get a judge, because judges are humans too.
Yeah.
But here's the thing. There was a point in this trial where Judge Carroll reached that, where Judge Carroll told Howard Hunter, what you are telling me is different than what I am seeing.
Yeah.
And the judge also has the added stress of having to maintain the record in a way that is protected against attack on appeal. So you have to make rulings, not just fair.
But again, with all possible respect,
courts
get the right to issue orders. They get the right to have their orders enforced. And you start relatively small with sanctions. You obviously don't leap to the end of the page because you need to give them opportunities to conform. So you start small and you escalate and you escalate and you escalate, and then you start reaching the non-monetary sanctions, like get rid of a defense or a witness or something, and then you reach the ultimate sanction of how about you just lose. And a court of appeals would uphold that.
I don't disagree. And this is the part
the standard at that point is abuse of discretion, right? Because it's like
this is the part where I lend grace. I lend grace to attorneys who have practiced before and who are sitting as judges who have practiced before. And honestly, when I'm looking at this, I'm looking at the ultimate outcome. And you look at the back and forth pissing contest for what it is, like a lot of the motions, etc.
Yeah.
The plaintiffs succeeded. They won. They won one of the largest judgments I have ever seen. One of the largest judgments ever reported. I mean, they won against a hospital that had every resource available to them. And yes, they did it at times with a thumb on the other side of the scale. I think the judge didn't intentionally put his thumb there. I think that is, if you want to call it institutional bias, call it institutional bias. That's fine. Call it that. Because I think that's probably the most accurate way of describing it. If it's institutional bias for the larger entity, how could this entity do these things? We're going to give the entity the benefit of the doubt. We're going to say that you're barking up the wrong tree. I mean, I see that with school board litigation all the time, where you see judges bending over backwards you're going, why? Why are you doing this? And it's cases like this that I very much hope are exemplars to future judges who see this and get to see the chicanery just played out for everyone to see in public. And for the judge, because hindsight's 2020, right? If you gave Judge Carroll the same case and you took him at the end and you asked him to make the same judgment calls he made along the way, I think he would have made different calls.
It's not just him though; it's the two judges that preceded him in this case.
Correct.
Apparently, it's a trio of weak judges, which is also very disturbing.
Institutional flaws.
I mean,
So, and I take this point to heart too. Here's the thing. I take this point to heart, Marianne. Rob, what you're describing is exactly how Murdoch and Girardi got away with what they did for so long. You're right. And same with this one. Murdoch had a jar of had a garden of jars. One misplaced coin would break the first jar. And that's the problem. But that's also why I want cameras to stay in the courtroom. I want judges to have the benefit of hearing from people who are observing, because they don't get a lot of feedback. The feedback they get is from the lawyers in front of them and the appellate court who tells them they were wrong or right. They don't get to perceive a lot of the public response to what they're ruling on. I want that to change. I want judges to see the public change, and I want them to change the way they preside over cases.
I don't know if it's naivete, and if you want to call me naive, I understand. But with the U.S. Supreme Court, the words carved into stone, at the entrance to the Supreme Court, so they're visible on the street, is equal justice under law.
Under law, yeah.
And Lady Justice has a blindfold because she doesn't care. She doesn't care if it's JHACH, and she doesn't care if it's Maya. She doesn't care. She is purposefully blinded herself by putting the blindfold on by choice to not see. And I don't know if it's naivety, but I still expect. I understand what you're saying. I understand it to a degree, but maybe it's naivety, but I can't get behind the degree to which it's been displayed in this case. It's just JHACH is such a powerful institution. What about equal justice? What about JHACH is equal to Maya? How about that?
Well,
is that too much?
No, I think you're right to reach that conclusion. I really do. I think you're right to reach that call. But, like I said before, I've talked about mistakes I've made, things that I've said, things that I've done that are regrettable, but you can't. You have to give people the benefit of understanding that they can learn from their past mistakes. So I'm not going to judge Judge Carroll based on this case. What I'm going to judge him on is the next one. The one where this is on full display. Like right now, Judge Carroll, you have seen how you, the court, were manipulated. Are you going to allow that again? And Kurt, you're right, but you're right. I know the skepticism. I understand it. He's been a judge for a while. I get the skepticism. But I always want the system to do better because, as you said, the system is not perfect. It has a hell of a lot of flaws, but it's the best imperfect system we have. The only thing we can do is work our ass off to make it better, to fix the issues, to make sure that this kind of stuff doesn't happen in future cases, to make sure there's not another Maya. I want that more than anything.
Judge needs balls. Judge needs big judge balls.
Oh, and this day on the 15th, I'm going to be very
My
curious.
expectations are so low for the 15th because why would he do anything now if he hasn't done anything before?
I understand it.
Like, give me a break.
And
as the trial's over, what can he even really do at this point? I mean, come on.
I mean, how many times are you, as a jurist, going to allow an attorney to, I don't mean to say this, how many times are you going to allow a attorney to spit in your face and tell you it's raining? Like, there has to come a point. And I think that this motion is the perfect opportunity. I mean,
Right.
I would rule in the damn pleadings, and I'd issue a show cause. That's me.
Yeah, I mean, you could do that if he wants to really have big balls. He could be like, well, in the alternative to the jury's finding, because if you're effing around, I also, in the alternative, issue a directed verdict. So how about that? That'd be good.
Yeah. Or, Howard Hunter shall appear and show cause, if any he has, why he should not be held in contempt for filing a pleading that by all appearances it looks as though it was filed in bad faith. And when an attorney gets show cause, an attorney can be held in contempt, and there's the toothbrush.
Hmm.
Now that's
Well, we don't need to go toothbrush. We can go monetary fines, and we can start small and work our way up. We don't need the toothbrush unless you're like actively disruptive in court, But
I think I'd like to see a threat of the toothbrush. That would give me a little bit of, you recognize what's going on. Like, Mr. Hunter, bring your toothbrush. Why should you not spend? Why, based on this filing that was so publicly disseminated and so improper, why should I not tell you to spend a few nights confined? Why should I not send the lesson to every attorney that practices under you? Because your name is on that pleading, sir. But there are attorneys under you.
That's it, right? That when you sign that document, it's your ass on the line.
Why should I not set an example to every associate in your law firm to say that this is not how you practice law? Wouldn't that be a world? I look forward to that world carefully, because that power can be abused too. There are innocent mistakes that occur. I don't think this is one of them. But there are certain things where I don't think a checkbook fixes.
Power can go to a judge's head, and certainly mistakes can be made on the other end. Yeah, I'm sticking with you got to have some judge balls.
Here's a good one. I want this one. Going back to the first, give Hunter an option. Give him the option. Do you want to spend, you want to spend one night in the confines of the county detention center, or do you want to spend one night under surveillance at the JHACH surveillance room, the EEG?
I wouldn't bother. I would take the surveillance room every time. What are you talking about?
Well, and then have the video of the surveillance room made a part of this proceeding.
I can behave myself in the surveillance room.
Because JHACH required that all that information be displayed on public. Why are you above that?
I think jail sounds better.
I do too. So
we'll make you wear a sandwich board and parade outside the court. I am a stupid lawyer and I am wearing this sign. That'd be good. Something like that.
And people are saying with the commode out of reach. Oh God. Yeah,
we sentence you to have your kids treated by JHACH.
Oh, no.
Since you're so fond of it,
That was a part that I said that I wish I would have said louder at the time I said it, was when you're talking about the jury as 6 people at a bus stop. The perspective is entirely wrong. Those are 6 parents.
I made a whole video about
patients.
it. Yelling
like potential
at it.
patients. They're potential patients. They're potential patients of your hospital. Recognize that the people that just passed judgment upon you are prospective parents of patients that are going to be treated at your hospital. They just told you emphatically, to the tune of $261 million, that what you did was wrong. Recognize that. My God. It is wild. And Hunter, what he's doing here is he's only putting a highlight on all of the other misbehavior. Like, if he had just gone away, right? If Hunter had just allowed this to be entered as a judgment, all of that misbehavior, all that other conduct would you could arguably for him brush it under a rug. Now, no, you have drawn a massive magnifying glass to every single thing you did in this trial. Now we are hyper focused on the fact that there were 15 hearings on 35 motions to get iCloud data. That
That's
there were
so insane.
52 motions for summary judgment.
That's 52 motions. When you told me the number, I couldn't believe it because like
It's not
how
believable.
How many summary judgments can you possibly have? 2, maybe 3. 52? I mean, sure, normally 1, but maybe 2, maybe a third. But like, where do you get the leave to represent? 50 seconds. Jesus. Yeah. So I mean, tell me I'm wrong. Tell me that the judges collectively did not have their courtroom in control. Tell me they were not exercising their judicial role to have the authority to back up their orders. Tell me that they were doing the right thing. You know what I'm saying, dude?
I get it.
Hope
Tell me
always
away.
says, "Is that a lot?" Yeah, that's a lot.
That's a
Yeah.
lot, man.
That's a lot.
That is. It's not just 52 motions. It's 52 summary judgment orders that clarified what was still a live count and not a live count. Summary
Why?
judgment, for the people in the chat that are confused, summary judgment is granted when a person at the end of the discovery phase says there is no issue of material fact that is in dispute, meaning that if we take all of the facts that are known to us right now that are not disputed, judgment must be entered in favor of one party or the other. So basically, you take this world of evidence that you've amassed and you say the following counts should not go to the jury for these reasons. And you articulate them, and you have different bases, different legal arguments to make, and you do. And what the result of that is a judge says, I'm going to grant summary judgment on, count 1 that says battery, right? You do not have enough evidence that meets the threshold to get presented to a jury. Therefore, I'm granting summary judgment. Or conversely, you can say, you do not have enough evidence to get to the jury unless A, B, C, D, E is presented in court. Or you have enough, but only if A, B, C, D, E. You can carve out things in these orders that essentially lay the roadmap for the lawyers to navigate. Now, usually a case will have 1, maybe 2, maybe 3 roadmaps. Summary judgment will leave the counts remaining, and they will lay out the roadmap for the lawyers to navigate and say, this is the route you have to take. You are constrained here. This is what you have to do. This case had 52 roadmaps.
That's, again, there really should be 1, 2, maybe 3. 52?
Not
52?
52. And 35 motions for iCloud data. Now, granted, those were spread across multiple witnesses because, as Greg Anderson had said before, this is the case. I mean, this is basically Tom Brady on steroids with the missing phone. There were more missing phones in this case than you could ever imagine. Basically, every single doctor, physician, nurse, treating caregiver, social worker, everyone who had anything to do with this case, apparently their phone decided that it wanted to take a drink.
Yeah. And you know what I would do as a judge at that point? Say, order show cause, and you say that under oath with all declarations. At that point, the judge, I say, I do not believe you. I do not believe that is possible. I make a finding of fact that you are lying to me. As a result, I will issue sanctions until you produce the data, and we work our way up, and then I issue my default. Because I can absolutely do that.
Yep. This is so
why didn't that happen?
Let me count the ways. That's the thing. Like you can go back through this case and you can see. I mean, the fact I've made this comment before. The fact this case went to trial, that made it to trial, and I know that people disagree with me, but when you read the bright line, like black and white law on this case, having the facts play out in a way that allows this to get to a jury is remarkably thin. It is hard to get here. every presumption favors the hospital. Every presumption. To get here, to get to a jury is, I mean, that is an undertaking. And to know the fight you're going to fight, I'm astounded that at the litigation in this case. So
let's talk about something else.
Yeah, let's do that. I did see, hang on. I need 1 second. I did see, do you want to talk about are you giving bar lessons to BeeFish?
Oh yeah.
Can you talk about that for 2 seconds?
Sure. Yeah. So BeeFish wants to learn a little bit more about the law because he was very interested in this reality about how he came into being. He's like, I came into being because of court decision. I was like, you sure did, BeeFish. I was like, and BeeFish, said that's kind of interesting. Can you teach me a little about the law? It's like, I'll certainly try to. So BeeFish and I have been having some lessons, and BeeFish has also been teaching me how to buzz in an ocean, which I told BeeFish I don't have either wings or fins. And then BeeFish told me, don't worry about it. Remember, I'm a BeeFish, so don't let reality stop you. And I thought that was a pretty good argument. So I've been learning how to buzz in the ocean despite the lack of fins and, wings, and it's going pretty well. BeeFish and I are getting along famously.
And I hear that you're training BeeFish to pass the Florida bar. Because
BeeFish is thinking about it, taking a swim in the ocean. He's a freshwater fish that swims in the ocean. And if you're thinking to yourself, that sounds like a contradiction. It's a BeeFish. So he's thinking about taking a swim. Yeah. So,
It's Callie. Callie's a she. Callie's a she.
She is a she. Yeah. So, so she is thinking about taking a swim from California to Florida and experiencing what the other side of the coast has to offer. So, yeah.
Yeah. Okay. So I know there's super chats that are starred on this topic. I'm going to bring it back up towards the end when I answer questions and go back through this other stuff because it's a lot to get through. Actually, Mischief, I just saw your note. There are a lot of super chats I cannot see. Can we go through those quickly? Because
I can see them, but I can't bring them up on screen because I don't have rights.
Yeah, the last one that I see is, hey Runkle, how was The Desperados by John Kissinger? Can we bring up everything before that? If there are and focus on questions, I'm going to shift to the next topic. I'm going to swoop. I think you hit a lot of questions. So, oh wait, Kurt's holding the swoop. Hang on, no. Good swoop pose. So, if you can bring those up at a natural pause, tell me when you're bringing up questions, and I can highlight those as well. Thank you, honey. Very much appreciate that. So the next story that we're talking about is this one. The Jacksonville Jaguars. A former Jacksonville Jaguars employee is accused of stealing more than $22 million from the NFL team to fund their lavish lifestyle. CNN reports this week that a former employee of the Jacksonville Jaguars, an NFL football team, has been accused of stealing more than $22 million from the NFL team to fund a lavish lifestyle, according to court documents filed in the U.S. District Court this week. The court filing says that Amit Patel used the money to fund online gambling, pay for private travel and accommodation for himself and friends, as well as sporting tickets, acquire a new Tesla car, Nissan pickup truck, purchase cryptocurrency, and buy a property in Ponte Vedra Beach, Florida. He's also alleged to have bought what is that?
Patek Philippe. It's a very expensive watch, about $100,000. Yeah,
it's a watch. There are watches that are worth $100,000.
Yeah. Patek Philippe. Yeah. They're very, very expensive.
Paying the entire price with, quote, proceeds from his fraud scheme, end quote. According to court documents, Patel is accused of wire fraud and illegal monetary transactions, stealing millions via the team's virtual credit card over a 4-year period of time. God. Patel is accused of stealing money from an organization referred to as Business A, but the Jaguars confirmed to CNN Sport that they had employed Patel and were the victim of his alleged crimes. We can confirm in February of 2023, the team terminated employment of the individual named in the filing. The team said in a statement to CNN, over the past several months, we have fully cooperated fully with the FBI and the U.S. Attorney's Office for the Middle District of Florida during their investigation and thank them for their efforts in the case. You got duped for $22 million, guys. As was made clear in the charge, the individual was a former manager of financial planning and analysis who took advantage of his trusted position to covertly and intentionally commit significant fraudulent financial activity at the team's expense for personal benefit. The individual had no access to confidential football strategy. Oh, thank God. I mean, he only had access to the 22 million personnel or other football information. Really? Just really? We're worried about the football info. The team engaged experienced law and accounting firms to conduct a comprehensive independent review, which concluded that no other team employees were involved in or aware of his criminal activity. CNN has reached out to Patel's lawyer for comment. They wouldn't comment if they were smart. In the filing, Patel is said to have been the sole administrator for the Jaguars VCC system. A VCC system works similar to any traditional credit card account, but without a physical card.
Yeah, some services, I think it was Chase, I want to say, that offers this to consumers as well. Where you can generate a new credit card number as a one-off that's tied to your regular credit card for like online payments. So
Will Robinson.
That way you don't have to worry about any online theft because the credit card is only valid for the one transaction. So you don't have to worry about it being stolen.
If someone has the keys to the system, they can commit massive amounts of fraud without any detection.
Yeah, because they're all different credit card numbers. Yeah.
Okay. Between September of 2019 and February of 2023, when he was fired by the team, it's alleged that he created an elaborate scheme to siphon money while avoiding detection. For example, to hire his fraudulent VCC transactions, the defendant identified legitimate reoccurring VCC transactions such as catering, airfare, and hotel charges, and then duplicated those transactions. Oh, baby. He inflated the amounts of legitimate reoccurring VCC transactions. He entered completely fictitious transactions that might sound plausible, but that never actually occurred. And he moved legitimate VCC charges from upcoming months into the month of the integration file that was immediately due to the accounting department. So basically, he saw a charge, and the accounting department was handling charges for the past 2 months, right? 2 months ago. And he goes, no, this was this week. But he goes, oh, no, it was back then. So they wouldn't catch it in this week. Patel waived his right to an indictment, and the case will proceed based on the sworn information by federal prosecutors. Who are those prosecutors that we say? They are these individuals. This is a press release by the Justice Department. Central Florida man charged with almost $20 million in fraud. So U.S. Attorney Roger H. Handberg announces that Nikesh Ajay Patel, formerly of Orlando, has been arraigned. He's 38 years old, man. This is pretty clever. And that's a lot of money over a short period of time.
He got away with it for a long time, so it wasn't that bad a scheme. Probably did what everyone does, or a lot of people do. You know, the white collar people tend to be very, very careful the first time around. And they tend to get bolder and less careful as they move on because they become complacent. And so eventually they do too big a thing while not paying enough attention. And then they notice the thing, and then they unwind the clock and they find all the things. And that's how that usually goes.
And the feds are very good at the money tracing. Like, of all of the entities that are good at money tracing, the feds are the best. which is funny because they can't trace the money in their own federal budget. But that's neither here nor there. Patel has been charged with 1 count of conspiracy to commit wire fraud, 3 counts of wire fraud, 1 count of conspiracy to commit money laundering, and 8 counts of money laundering. He faces a maximum penalty of 30 years in federal prison for each count of conspiracy and wire fraud, and up to 20 years in prison for each count of money laundering. That's a lot of years if they get the conviction. What was curious to me was this: he's been arraigned while he was on pretrial release. So he was arraigned on charge relating to almost $20 million in fraud that he perpetrated while on federal pretrial release. So did they get him on 1 count and they did the investigation while he was on pretrial release and got the rest? It has to be that way, right?
I'm not 100% sure what that means, but I'll pass. I'll ignore it and move on.
Oh, never mind. We have our answer. According to court documents in 2014, Patel, a Central Florida resident, was charged by U.S. Attorney's Office
for $179 million of fraud. Well, damn.
Wow.
This guy is big in the fraud game. Okay. Big balling.
He was arrested and released on bond. For the next several years, he claimed that he was cooperating with authorities and using his business skills to get funds to repay some of what he owed. In fact, he had devised a new scheme that netted him almost $20 million.
So he claimed that he was cooperating with authorities to help repay the. That's really good. He said he was cooperating with the feds to help repay some of his debt, and the way he was doing it was by more fraud. That's one way to go, I guess.
This is a brass ones this guy has. My gosh. Patel's new fraud scheme involved 3 parts. First, he fabricated fraudulent loan documents that falsely represented that a bank in Miami had authorized loans to be made to convert hotels in rural areas into assisted living facilities. Oh no. He's one of those fraudsters. Really? Although the bank in Miami exists, it never made any of the loans. The person who was listed as signing the loans does not exist, but was a fictitious entity used by Patel to perpetuate his conspiracy and scheme. Second, he applied to the USDA, the U.S. Department of Agriculture, to guarantee the fake loans pursuant to its business and industry guaranteed loan program. Third, after the USDA agreed to guarantee the fake loans, Patel sold the guaranteed portion of the fake loan. Dude, this is smart.
Wow, that's an option. Wow.
So he sold the servicing rights to the loan. Like he sold the collection rights to the loan to another federal entity, the Federal Agricultural Mortgage Corporation, known as Farmer Mac. Freddie Mac, Fannie Mac, Farmer Mac. Freddie Mae, Fannie Mae, Freddie Mac, Farmer Mac. Oh my God. This is Patel executed the scheme on 3 occasions, receiving almost $20 million in proceeds. He used a portion of the funds from that scheme to pay some of the restitution, but he was saving much of it to flee the United States. He didn't do it fast enough. His sentencing. Oh my God.
If you receive $20 million,
this
at the risk of asking a stupid question, just how much money do you need to flee the United States? I mean,
1,000, 2,000, 3,000, like if you're fleeing.
Maybe a couple million if you want to live a good life in Hong Kong, but yeah. So
this is the previous scheme. Oh, his sentencing in Northern District of Illinois was set for January 9th of 2018. 3 days before that, he was arrested at the airport in Kissimmee, which is in Florida near Orlando. Patel had chartered a flight to Ecuador where he was going to request political asylum and live off the proceeds that he obtained from his new scheme. Well, instead, his bond was revoked and the U.S. Marshal Service transported him to the Northern District of Illinois. On March 6, 2018, he was sentenced to 25 years in federal prison for his case in the Northern District of Illinois.
Okay, so he already has 25 years and he's looking at some more. So, yeah.
Yeah.
So I think he's going to be spending some quality time in Club Fed for a while.
I would say so. His indictment in the Middle District of Florida relates to the conspiracy and fraud scheme that he executed while he was on pretrial release.
You
So
do realize one of the
apparently-
conditions of release is not committing new crimes, right?
I mean, but Kurt, I mean, you said it before, like this guy didn't want just 20 million to flee. He wanted more. What the hell?
If you give me 15 million, I'll flee. You'll never see me again. I'll be doing my podcast from Hong Kong.
I love this caveat. An indictment is merely a formal charge that the defendant has committed one or more violations of federal criminal law, and every defendant is presumed innocent unless and until proven guilty. Thanks for that clarification, because it's pretty sure like there's receipts. Like I'm pretty sure that based on this,
I'm guessing, being convicted of other frauds probably isn't going to particularly help either. So yeah, in 25 years, he's going away for a while. Even if he gets only another 25 years, he's spending 50 years behind bars. So
well, then we've got this one. So that was that. Then you've got this. The defendant used. So this is the pleading itself. Defendant used his authority over business A's VCC program to charge approximately $22 million, $221,454.40 in fraudulent transactions. Began making fraudulent in
a lot of transactions.
September of 2019. How did it take that long? Like 2019 till February. You were just were you not looking?
He tried to hide it. I guess he was able to hide it in a way that didn't show up somehow.
It's smart hiding. This is a person who is. This is scary. When people are this good.
Yeah. I feel you.
Okay. Mischief, bring up those other two, and then you can bounce. I have pancake breakfast with Santa tomorrow at 9:30 a.m.
Sweet.
With mini mischiefs. So Stephanie 1208, it's my birthday. Can I get a shout out by my fave trio? Well, you have the dynamic duo, but we will do a birthday shout out.
Happy birthday to you. Happy birthday to you. Happy birthday, dear Stephanie. Happy birthday to you.
Lovely. Happy birthday. Tracy Curtis, I'm asking you all to pray for my twin, Lacey Pritchard, to beat her cancer. May she pound that cancer into the ground, that it never comes back, resurfaces, or ever bothers her again. It's a fight that's worth fighting. Never give up. Never, ever, ever, ever give up. Beat it back. You can do it. Your family is a blessing. Keep them close. Love them dearly. Hug them tight. So, well, those were two of the cases. How you doing? How's the endurance? Are we okay?
I'm feeling pretty good right now. I was really, really tired last night. I had to go to bed early, but right now I'm feeling pretty good. So that's nice.
I need sleep.
Pina coladas, getting caught in the rain.
You're not into yoga. Have a brain. You like making love at midnight. All right. Anyways, so let's see. I've got myself somewhat caught up on some of these super chats, and I'm going to save the rest for quite a little bit, because I want to make sure I make it through the last topic. And that one is, we did Jacksonville.
What is love? Baby, don't hurt me. Don't hurt me no more.
Wait, I have to go the right way. No, wrong way.
What is love? Okay.
That made me dizzy for a second. Anyways, this one caught my attention earlier today when it was published. An inert rocket launcher was found by a worker in a New York City basement.
Cool.
A worker unearthed a settling find. Oh, wait, hang on. Swoop. Swoop. Callie, what are you doing? Anyways, a worker unearthed an unsettling find in Brooklyn basement on Friday, a rocket launcher, according to law enforcement sources. The device was deemed inert. Well, if this is what I'm finding in my basement, I have concerns. The explosive discovery was made by, oh God, this is just terrible journalism.
I mean, not for nothing, but it wasn't explosive because it was inert, but never mind. Okay.
The explosive discovery was made by a worker this afternoon in the basement in East Flatbush. Okay. 3-story building temporarily evacuated. All right. So there we go. Now, our last story of the evening is one that I know that you've covered. And I am very excited to hear your commentary on this one.
I thought this was really cool. I thought this was really, really cool. And there was such an interesting detail about this. I don't know if your story has the detail, but if it does, and I'll bring it to light.
Do you want the story or the pleading? Which one do we want?
The story's fine by me, man.
Is the pleading any good? You know what?
I haven't read it. I just read the story.
Oh, okay. Let's do that then. Because I have the pleading.
Okay.
Defendant's motion to require adherence with the formatting requirements of Local Rule 7.1.
By the way, just in case we need to set the stage just a little bit, they're literally fighting over what double spacing means. Just to make this clear, the rule requires that they be submitted double space, and we're literally having a fight over what double space means.
Yep.
Okay, carry on.
That's where we are. Carrying on. So this is filed in the Western District Court for the U.S. District Court for the Western District of Tennessee. Jones et al. Versus Varsity Brands LLC et al. Local Rule 7.1 requires that in pleadings presented for filing, quote, lines must be double-spaced, except that quotations may be indented and single-spaced, and headings and footnotes may be single-spaced, end quote. All widely used word processing systems, including Microsoft Word, Google Documents, and Apple Pages, use 28, quote, points, end quote, of spacing when set to double-spaced lines.
Yeah.
Is the lead-in good enough? Like, is this doing the story justice?
Yeah.
In the process of preparing replies in support of defendant's motion for summary judgment, we talked about those. Defendant discovered that plaintiffs have, with regularity, overrode the standard double space setting and instead spaced their lines 24 points apart. This has enabled plaintiffs to have approximately 27 lines on each page, rather than the approximately 23 lines per page that would result from formatting using standard double spacing. By doing so, plaintiffs gained approximately 7.5 additional pages for their statement of additional facts and approximately 17 additional pages for their legal memoranda opposing summary judgment. Now,
yeah, so like you in middle school and high school, they effed with this line spacing to change the page length and hope the teacher wouldn't notice.
This one, like we're reading this part above it, it sounds ridiculous, right? But when you get to this part, I mean, this part is pretty significant. 7.5 additional pages. And 17 additional pages of argument?
Yeah. And amazingly enough, other courts have had to resolve this problem before. There's apparently some division of authority, at least on the district court level, on this question. So that's exciting.
What is it? Ian has a rule in his his Discord community that basically says, "Don't make me make additional rules."
Yeah.
Doesn't that seem fitting here? Don't make me
Yeah.
make an additional rule that tells you idiots
Yeah.
what double spacing is.
Yeah.
So,
So-
footnote, these calculations are based on approximately 4 additional lines per page, a 49-page statement of additional material fact. So we're dealing with very large briefs and 99 pages of legal memoranda. So, yeah.
So since it won't be brought up in this motion, because why would they? It will be the opponent's response. Let me tell you what their response looks like. Their response says, okay, back in the typewriter era, double space was literally just double because it was based on hitting the return, right? So it didn't know when you, yeah, so you didn't know, obviously the typewriter didn't know when you hit next line if you're going to type or not. So it would just insert a blank line of the exact same width as the line that you used before. Okay.
Oh, wait,
so that's
wait,
what double.
can I interject with something?
Sure.
Taylor Swift, I've got a blank space, baby, and I'll write your name. Blank space. Yeah,
Sure.
Sorry, that was
No problem.
Nothing.
So apparently, according to the other side of the equation, Microsoft Word, when they were creating their standard, did instead of 2x, double spacing is actually 233%. And so they changed it according to Microsoft because they thought it looked nicer. And then everyone adopted their standard. So now there is the dispute about what double spacing means. And what's particularly interesting about it is for official transcripts, it's actually spelled out in point size. Instead of saying double space, it literally spells it out in exactly how many points it has to be apart to avoid this confusion. But the lawyers haven't gotten the memo yet. So basically what happened here, to make it easier, these people went from the Microsoft standard double space to actually true double space using the terminology as it would have been understood in the typewriter era. So that's the dispute. Does double space mean what Word says or what the typewriter says? Now you know all you need to know.
They lawyered the shit out of it.
There were apparently 9 law
God.
firms involved in this. There were 9 law firms involved in this.
This is the best legal argument ever. This is amazing. This was not in accordance with the rules requiring double spacing. And this apparently,
amazingly enough, the rules don't define what double spacing means.
They don't. So plaintiff's counsel abused the page limit. So this is a reported case. Plaintiff's counsel abused the page limit and violated the local rules by reducing the line spacing to slightly less than double space. This means that rather than having 23 lines per page, they had 27. So that's a case on point. District court.
Yeah.
Actually, I take that back. That doesn't look to be reported. That looks like an unreported.
So
double day.
They're both unreported.
Surveying cases concluding, local rules. Text to be double spaced between lines required parties to use word processors default double spacing option rather than exact
spacing.
Ooh.
Yeah. And as I said, there's a division of authority on this among the district courts. So we're setting ourselves up for a potential Supreme Court fight someday on what double spacing means. How exciting.
Oh, please give me this. This is amazing. I need this in my life. There don't appear to be any cases in this district pertaining to this issue. During the meet and confer, they meet and confer. Oh my God, this is amazing.
Yeah.
Plaintiff pointed the cases from districts in Ninth Circuit to the effect that the 24-point spacing complies with those local rules. In particular, these cases, at least one of those districts has local rules expressly allowing documents with up to 28 lines per page.
Yep.
To ensure a level playing field going forward.
See, as I told you, there's a division of authority. That's what I told you, man.
Wow. Tech giants are playing with everything, man. They want an order that requires counsel to conform with the default spacing requirements of Word, Google Docs, and Apple Pages.
Yeah. It's great, isn't it? It's glorious.
This is the best thing in the world.
Yeah.
This is where we are right now. It would take a case with this level of briefing to get you to this level of argument, because
Mm.
everyone always says, what's it such a big deal? And I always kind of argue, like, take that argument to its logical conclusion, like go to the very nth degree, make it extreme, go to that, make the argument, make the point, and now see why it's a big deal.
Mhm.
To give an opponent 7 additional pages of facts,
Mm.
17 additional pages of legal argument. Do you know how precious those words on a page are?
Yes. Oh yeah, no doubt. If you want to cram in more argument, man, that's a godsend. 17 more pages of argument I can get away for free, man. Boy, oh boy, that sounds pretty good. If I want more pages, yeah.
Yeah. Like we are talking about cutting out, like taking longer words, like words that are, 10, 15 characters, and finding simpler words that are 4 or 5 characters to say the same things. There are editors that go back through pleadings and briefings to go and refine this stuff.
Yep. Yeah.
Oh my God, this is amazing. I cannot believe that this is actually the subject of controversy. But
Now, just to bring this to its zenith of how serious they got about this, because I think this detail is so interesting. The other side of this equation, to argue the point, brought in an expert witness.
no,
Okay. The expert witness is a man named Matthew Buttrick, who is both a lawyer and an expert typographer.
no, this
And
is not
he-
a real thing.
And he wrote a book called Typography for Lawyers. So there is, in fact, a guy who is both a lawyer and a typography expert who literally wrote the book on typography for lawyers, and they hired him as an expert witness. Great. That happened.
Oh my God, this is my favorite thing. This is my new favorite thing. Can this oral argument be, can I hear it? Is it federal?
Yeah.
No, it's federal. Damn it.
And the people who wanted the more pages won the argument at the end of the day. So there is yet more circuits, more divisions split. So apparently the expert witness got them what they needed. The one guy, literally the one guy, because how many of them can there be? Both a lawyer and a typography expert who literally wrote the book on typography and law. He's literally the guy. There's only one of them.
Imagine a circuit split. Imagine an actual circuit split where the Circuit Court of Appeals takes up this issue, and there's the one expert, right? There's the one expert, and lo and behold, dramatic scene plays in the background, fog and mist slides to the side, and there's a second expert.
Apparently they not only got him to submit a formal declaration on the subject, the declaration also included an image of him using a ruler to measure the lines in their plaintiff's brief.
This is the second motion we've covered today that has me like at a loss for words, and this time it's actually for a positive effect. This is wow.
Yeah, literally broke out the ruler in his official declaration.
Now, I want to tell you how courts of appeals change this. So in Virginia, the Court of Appeals, when I submit a brief in an appellate argument, I have to identify at the very end of that brief the total number of words. I'm limited in words, not space. This is what we're going to. We're going to this format, man. Oh my God. And now here's the other thing you're going to see lawyered next. They're going to go to a word thing, like a word limitation. And one of the things that's exempted from my word count are my footnotes. So you're just going to see
massive footnotes. Yeah.
Footnotes. They're like a whole page of argument is a footnote.
Yeah.
See footnote 2.
Yeah. And one goes on for 30 pages. Yeah. Yeah.
I need this to be a circuit split. Can we have the Supreme Court wait? I don't have any impact or influence on what the Supreme Court does or does not grant cert to, but please, like, we need this as a society.
Yeah.
Speaking of Supreme Court,
Or I
what have
suppose
been
if you want to
covering?
be really old school, you could just go to a typewriter, and they can't object to that because the typewriter's still legal. Maybe
mean,
there's a way to use it.
DC
Maybe there's a way to hook up a word processor to a typewriter, so you can finish it in the word processor and then get the typewriter to type it. That'd be good.
like just to make it.
Yeah.
DC used
There's got to be
DC
some.
used to
There's got to be some
require-
solution for that.
Like up until like 10 or 15 years ago, DC used to require the lawyers to take their bar exam on typewriter.
Really, it's funny.
Yeah, just like the lawyers in Virginia, we have to wear the suit and the rubber.
Yeah,
you remember
suit and
that
tie.
suit?
I'll
suit and
be
rubber
in my
shoes?
suit and tie. Suit and tie. I'll be
the-
in my suit and tie.
The suit and the tennis sole
Let me
march.
show
the
you
tennis
a
shoes march.
few things. Few things. Few
Because the
things.
clickety
Little
clack,
baby girl. Yep.
clickety clack of the leather soled shoes
Mm.
and the high heels or the heels in general just were too distracting. So lawyers in Virginia have to take the bar in a full suit and a tie and rubber soled shoes, so tennis shoes. What will they think of next? Supreme Court, what did you cover this week? Give me 1 second. What did you cover this week?
Okay, well, today I actually did a Supreme Court oral argument review on the case of United States versus Romini, dealing with domestic violence and gun rights. The person in question had a domestic violence restraining order against him, which prohibited him from owning guns. He then, after that, went and, did many shootings at people and, various other criminal misdeeds. The police, in investigating said crime, went into his house and found a firearm, and the feds prosecuted him for violating 18 U.S.C. 922 G8, which prohibits a person with a domestic violence restraining order from owning guns. The Fifth Circuit Court of Appeals said that this violated the Second Amendment, and what the issue was supposed to be was whether or not people who have a domestic violence restraining order can have a handgun or other firearms. And the Solicitor General had some negative. The Solicitor General, Miss Prologar, who is fantastic, by the way, I really like her.
I love Prologar. Prologar. I call her Prologar, but she
was a little bit short on the law, so she didn't really have good legal authority. So she had to come up with good arguments, and she had an interesting way to address the problem that raised its own problems, of course, because you're trying to do something a little bit novel. But she tried to contain it and satisfy the justice's question. And then the attorney for Romini in the first half was great. He was so good. He gave this, drop the mic answer to one of Kagan's questions. 10 out of 10, absolute perfection. And in the second half, he absolutely shit himself in the pants. It was an atrocious, absolute train wreck where he wound up completely contradicting his argument. And the justice was the justice, everyone. Like initially, it was Alito, and it was Kavanaugh, and I think it was John Roberts. Like they tried to save him like 3 times, and then I think it was Kagan who then said, "Wait, I'm confused because this completely contradicts yourself," and then he just ran into a Yeah. Then it got so bad that even Ketanji Brown Jackson basically asked a question trying to save him because it was such a train wreck, and it wound up into an absolute sea of confusion where his argument made absolutely no sense. Basically, he completely sabotaged his Second Amendment argument completely in the foot and just started making due process arguments, which it was not the issue. He said very clearly, and the briefs clearly said, this is a Second Amendment problem. The courts can't do this. And then he said, well, maybe if they did this, this, and this, it would be enough. And the courts are like, wait a second, that sounds like a due process argument. You're upset that your client didn't get enough process. You're not upset that the court did it in the first place. And he just completely, absolutely, it was an absolute train fire. I had not gotten up and literally beat my head against the wall in quite some time. But I got up during oral argument and literally beat my head against the wall because it was so bad. It was an atrocious, absolute train wreck of a disaster of an argument. And I think the conservative justices were looking at each other like, how would you like to dismiss improvidently granted? Would you like to dig it? Would anyone up for that? because it was a trash fire.
But I can see how making that argument, you could fall into the due process, because to be honest, so to be clear, you can, by your own actions, forfeit your right. You can forfeit your own right by your own actions, right? Felons, convicted felons are not allowed to lawfully possess a firearm. You lose the right to vote. You lose certain rights by your own conduct if you are afforded due process in the deprivation of those rights. And if the deprivation meets a certain standard, strict scrutiny in this case, because you have a fundamental right, strict scrutiny.
Right. But that was his whole point. Like, that was the whole point. There is no process sufficient enough, because this is a violation of my Second Amendment right. There is no process sufficient.
It's just
that was the idea
of the fact that there is an order of this effect that's a deprivation. Interesting. It's but I can see how he fell down that slope.
I can't.
Someone baited him into the argument.
No, he didn't. They didn't bait him. They didn't bait him. That's the thing. That way? Alito just asked a completely generic question, and he just wound up completely sabotaging himself. They didn't bait him. He did it all on his own. And then he just continued to do it for the next 15 minutes or 20 minutes or whatever it was, and I wanted to die.
Did Prelogger just get up and rebuttal and basically say the government doesn't have?
Well, there was definitely a line there basically saying, I can't help notice that my friend on the other side, my learned friend has basically conceded the argument and said this is really a due process problem, which is not what the court was asked to decide. So,
by the way,
and also, by the way, he's making a facial challenge. That's the other thing, right? Because that's the thing. He's saying this is facially invalid. It's not as applied, right? So it's a facial challenge. So to win a facial challenge,
explain.
I was going to explain
facial versus as applied. Thank you.
Right. So if you're challenging a statute or a regulation, you can do it one of two ways. You can say either as applied, which means generally speaking, this law or regulation would be valid, but it doesn't apply to me because of some special reason that applies to me. And that can work depending on what your special reasons are, right? Or what the situation is. And as a facial challenge is you're literally attacking it on its face, which is saying that there is essentially no way that there's any valid way to do this. It is invalid in every possible use case or close to it, right?
Let me try to rephrase.
Please.
So the facial challenge, the words on the page read aloud don't make sense. The words on the page read aloud fail. That's facial challenge.
Right.
As applied, the words on the page as you read them do not fail. The second that you start applying those words in real life, they fail.
Right.
That's the
So
the dumb way of saying it.
So he's going on a facial challenge. He's like, there's essentially no valid way. There's no valid application. There is no valid application, not as applied to me, but all applications. There's essentially no valid application of this prohibition because Second Amendment. And then he gets up there and he says, well, if this had happened and this had happened, that would be 100% constitutional. So you're conceding there's a valid application. And the Chief Justice actually asked him, so why aren't we done? And what should have been a pretty big clue. Why aren't we done? Because you've conceded there is a valid application, and that's the end of the game. So, and it didn't get any better at any point. It was an atrocious train wreck, disaster fire of a case. So, if you want to entertain yourself with me slowly losing my mind and tearing out my hair and losing the last of my sanity, you can go watch that stream. It was fun.
I mean, I will tell you that Attorney General Prelogger is. I remember listening to her a couple of years ago, and she's a bright star in that department. By the way, like she's a superstar. She's really good. She makes the arguments that you need to make, and she's very good at graciously making the arguments that she has to make, but doesn't want to make.
Yeah. And she was doing very good because she was doing very good of basically dismissing her counterpart from like 20 years ago because
Yeah.
the Supreme Court has basically ruled, we're not interested in any sort of mean balancing test. We're not interested in, any of
And-
this. We get that out of your mind. We have no interest in any of that. That's not what we're talking about. So, yeah, she's very good, and she knew the cult record, and oh my God, just to show you how bad it was, like I can't even. The attorney for Ramini is up at the Supreme Court now. What do you remember? Basically, the core holding of Bruin, New York State versus Bruin. Do you remember what the core holding was? Remember that?
Yes, I'm going to misstate it though. Basically, it was a scrutiny test. It was that it was that they didn't apply the appropriate standard because they were looking at it in the context of something that Kurt, I'm going to mumble through words.
Yeah,
Please,
history and
you have it on
tradition.
top of your head.
History and
Yes.
tradition is how you simplify this,
The
which
wrong
incidentally
context.
is basically how you interpret the First Amendment and every other provision of the Constitution.
Yeah.
The history and context of what does it mean, right? So you would think, therefore, knowing the history would be a good thing as it relates to you. And he literally gets up in the Supreme Court and is like, well, I'm not aware of any history that exists. I haven't, maybe someone can tell me, but I don't really know. I'm like, how do you not know the history cold? How do you not know the history as it relates to this? Every possible direction. Because the Supreme Court said, well, what matters is history. And you're going to the US Supreme Court. So how about some history? I know it all because, of course, I know everything because I've studied for this like a good lawyer because it's the Supreme Court.
Did you ever prepare in law school or in argument? Did you ever prepare the appellate folders the way they do, the trifold folders,
Oh yeah, sure.
where you have the note
I also did
cards with
I
all
also
the
did briefs
cases?
both ways. That was fun too. I argued against myself. That was great.
And these lawyers, when they stand up, when I say they have practiced,
Oh yeah, no doubt.
that is,
They,
there is no practice like what they have done before they stand up. They
Yeah.
have different panelists that are the age, gender, stature, demeanor, and tone of the justices, and they have them shooting questions. They moot this out. They go
Yeah,
back
exactly.
and forth.
Of
They
course you
know
do.
everything.
Of course you do. You moot it out. You get a group of lawyers to tear you apart, preferably different lawyers. You go at it every possible way, and you read every brief and you know everything there is to know because you're a good advocate because this is the Supreme Court and you might want to know it. And he was just flailing around. I don't know the history.
There's
I don't
a
know it
thing
very
though.
well.
There's a thing about it though that is a comfort level. So our favorite, and I say our favorite Supreme Court oral argument advocate, and our favorite is who again? Paul Clement.
Yeah, Paul Clement. Yeah, for sure.
So our favorite advocate, Paul Clement, has been in front of the Supreme Court more times than trial attorneys have tried cases.
That's about fair. Yeah, that's about
His
fair.
level of comfort is such where he can look up at a Supreme Court justice and say, I'm sorry, you're wrong. Like he has that confidence and tell them
Yeah.
to their face, I'm sorry, you're wrong.
Yeah.
Logger has very quickly risen to that kind of level of experience because it takes a lot of practice doing that. But if you're an attorney that you're sitting there for the first time and second, third, fourth, you're there and a justice asks you a pointed question, you panic and you start double thinking the question. You start to try and think, what question are they actually asking? So you can get yourself tied up in this rabbit hole that you end up in. And all of a sudden you don't realize that you're drowning and the justices are throwing you lifelines and you don't realize they're lifelines. You think they're poison pills and you're throwing them away because you're going, I'm flailing in the water because I'm not used to this.
Yeah. Someone in chat asked what I meant by arguing against myself. It was one of the moot courts that we were doing on appellate moot court. And in any given round, you didn't know what side you were going to be, whether you're going to be which side. So I literally had to prepare 2 appellate briefs, 1 for each side. So I literally had to prepare a appellate brief. Here's all the reasons plaintiff should win and defendant's arguments are dumb. And here's all the reasons defendant should win and plaintiff's arguments are done. So that's what I mean by arguing against myself, because I had to figure out how to defeat myself and also not defeat myself both ways.
Yep.
And that was so much fun.
And
That
this
was
is what I
great.
loved about one of the things that law school does that I wish they would do this for trial attorneys. I
Yeah.
wish that they would show up. And actually we had an all hands meeting for my new firm, and one of the tasks that was given by the staff, all the staff people, the paralegals, the receptionists, everyone that is a support staff gave all the attorneys, the partners and the lawyers
Mhm.
and the associates, and they broke us up into teams and they gave us hypotheticals. And they just assigned the hypothetical, and they said, give the closing argument. And they gave us the hypo. And it was so fun because you see the staff who are the warriors that allow us to go into court and try these cases. Just like in appellate argument, the people that do the research for the briefs, they're the ones that know that stuff backwards and forwards. The lawyers.
I argued it in the 7th Circuit Court of Appeals courtroom. So that's how seriously we took the moot. We borrowed their courtroom for the day.
And that's the fun part about it. But you give trial attorneys that experience, and you give any trial attorney, you give them a set of facts. You say, give the closing, and it doesn't matter what side, they should be able to close.
Oh yeah,
and
for sure.
To see all of the different partners arguing against each other that we don't get to do very much. That was a lot of fun. And you give bad facts to lawyers, and the way that they argue it. And same with moot court. So you have to be able to take both sides of the argument and argue it with equal passion.
Yeah.
Oh.
Yeah. How do I create 2 perfect briefs which both defeat the other and don't?
Yep. And how do I argue one to beat the other one in the right moment?
Yeah. Yeah, it was great. And at the end, of course, I thought I did a pretty good job of it. I thought I had, and we made it through to the finals. You know, we didn't win, but we made it through the finals. So apparently I did do a really good job of, writing 2 arguments that both defeated each other and didn't at the same time.
Now, that brings me back to the point that I was going to make earlier, which is someone asked in the chat, like, how spicy does it get? Right. One of the things that I think is the best part about the Roberts Court. So they name the courts after the Chief Justice presiding over the court, right? So there's the Roberts Court, the Marshall Court, the Rehnquist Court. They name it after the Chief Justice presides.
Sure.
One of the best things about Chief Justice Roberts' court is this, my learned friend on the other side.
I like that. That's a good thing.
It's a new thing, but it forces decorum. And I love when I hear it in argument and you hear that little twinge of snark, like that, just that little twinge, like, well, I think I just heard my learned friend on the other side concede their argument. And it's like, you know that you want to say all the things, but Justice Roberts has been like, nope, we're going to behave. It's one of the cool things about legal practice that it's a small thing. And people are asking, does it force decorum or shade? No, it actually does bring a lot of decorum back to those arguments. You don't have yelling, screaming. You really do see some of the best lawyers act in the best ways.
I agree. I wish he hadn't imploded his case, but other than that, yeah.
What are they going to do with it?
Well, I really think that they're going to look for a way out. If they weren't looking for a way out before, I think they're going to now. So I think they're going to dismiss as improvidently granted, which we call dig in the trade, which means the Supreme Court pretends the whole thing never happened.
Yep.
Right. What Supreme Court case? We've never heard of a Supreme Court case. We have no idea what we're talking about. So they pretend the whole thing never happened. He had the guy who was appealing this, the Romney, had actually consented to the underlying order, the underlying restraining order. So I could see them saying, well, you can waive your rights, and he waived his rights. So, end of analysis. Or you could say, well, if the order was invalid, you have to challenge it through the proper process. You can't just violate a standing court order. You have to go, and there's plenty of case law around that. First Amendment cases like, someone is restrained. They think that's bullshit. They violate the order. The appeal court says, yeah, you're right. That was bullshit, but you still violated the order and you can't do it that way. You have to go through the process. So you still get whacked over the head. So there's 3 outs. And I imagine they're going to take one
It's
of
going to
those.
be a dig. It's going to be a dig. It'll be a dig because the consent part of it, it's too easy. And
Yeah.
yeah.
Because what else can they do? I mean, the only other thing they could do is pretend Romney's lawyer wasn't there and just try to graft something onto Prologar's speech and
Pre-logger.
pretend Romney never spoke. I don't know what else they can do.
I don't know. I like what I want to do is I want to see I wish if there was a world where AGs could survive administration to administration.
Yeah.
I want to see pre-logger go from one to another. Like I want to see her.
You know, she was in Miss America twice.
Seriously?
Yeah.
No.
So not only is she an accomplished lawyer, she's a beauty.
I've never seen her.
Yeah.
I've only heard her voice.
Yeah.
I want to see her argue the other side.
Yeah. I feel this is unfair. No one should have this much natural beauty and much natural talent. No one should be contestant for Miss America twice and also be a kick-ass lawyer. That's just too much for anybody.
Don't take anything away from Paul Clement. Paul Clement he's a handsome fella, and he also is remarkably brilliant. And like when I hear those two against each other, Paul Clement and Prelogger, I love it. It's legal jousting, and it's so much fun. Here's the thing. So there's a podcast. Go to your podcast distributor, Oyez, O-Y-E-Z, Oyez podcast.
O-Y-E-Z, O-yay, 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 O-Y-E-Z.
Exactly, O-yay. O-Y-E-Z. Go to that podcast and you can listen to the oral arguments. They release them 1 week after they're made, and you listen to the oral arguments. Just listen. If you're walking around, if you're doing stuff, if Kurt and I aren't streaming and you've already caught up on all of our streams and you have some extra time, listen. It is so cool to get the personas of these individuals. You can learn a ton from listening to those arguments. And when you hear that intellectual jousting, God, it's so much fun.
I agree.
Anyways, that was a nerd. I'm a Supreme Court nerd. Kurt's Supreme Court nerd. That was two nerds just nerding out on Supreme Court.
Yeah.
So.
Yep.
All right, I'm going to catch up on Super Chats and get out of here for the evening because I have breakfast with Santa.
Cool.
Santa, I know him. John Kissinger. Hey, Runkle, how was Desperado? I'm sorry. I didn't get to ask him that question. He's out partying with people that I wish I was out with, and so does Kurt. We should be at that bar. It'd be fun. Carol with C&E. Okay, in my opinion, this is what frustrates me. Lawyers are not held accountable. Some are. Part of making trials public, I see the crap that lawyers pull and nothing happens to them. Great example. Part of it is walking this fine line of recognizing that some of it is their obligation. So we are advocates. We have to zealously advocate for our clients, but we are subject to constraints in what we do. There should be accountability, but you have to be careful about where you draw that line. I agree with Kurt in a large part that some of the line drawing could have happened earlier in this case. Here for the truth. My son, 24, built his own gaming PC and loves it, but just came in to tell me it isn't working well right now. LOL. Thank you. Well, for the truth. Ian Paler, I'm glad to ship some 16 gigabyte DDR4 DIMM.
Somehow I doubt that Rob is using DDR4. I'm just going to take a rough guess.
I don't know the acronyms. I'm fine. I will figure it out.
We'll get it set up. We'll hook Rob up. We'll do fun.
I will figure it out. I did get a 3D printer, by the way. That's on its way. It comes next Tuesday. Kristen M96, side note, you can order Ian's pour one out design as wooded wall art. It's expensive, but funny. Thank you, Kristen. I didn't know I needed that. Lindsay, time to make a BRB computer on fire graphic that Mischief Manager can pull up when Rob's tech yeets him out of the stream. That's fair. Becky McKee, what sanctions could be given to JHACH? Money.
Death.
Money, mostly
Yes.
money, mostly money. And if it's the attorney,
Summary execution in the courtyard.
God, money and possible toothbrush. Kristen, juror number 1's avatar is a bot. They're going to claim he is a robot next. How is Callie's legal training going?
Yeah, I mean, we don't realize how much Juror would set himself up by being a bot because the bot's behind you. He's one of the bots. Conspiracy.
I love it.
Illuminati.
That's you know what? I did say that we're going to see a third supplement.
At least.
PFUS, can I get the TLDR on the motion for JHACH made? They called the juror a Yahtzee/Nazi.
Here's your summary. Callie's sad.
Yeah.
Callie's sad.
Yeah, it was bad. Carol with C&E, my first super chat, I forgot to say present lawyers excluded. Thank you, Callie. Carol, sorry. I said Callie. Carol. Kevin Collins, isn't that judge's bias then? I would say systemic issues, because I would say that's built into a lot of judicial training and experience. I think it's a way we got to fix it though. Dalton, could they be baiting the judge, not juror 1? I thought that too. They're asking the judge to basically give some massive sanction that then gives them a basis for appeal. But that would be separate from the judgment. I don't see that going anywhere because the Court of Appeals wouldn't overturn anything based on a sanctions order. So I don't think it gets them there. Elizabeth Love, Kurt, your point about judges not enforcing orders is on point. It's awful. The courts need to be a lot less tolerant of litigants playing games.
Facts.
Yeah, I think that's fair. It's a fair assessment. JPC, 1 foot on the ethical side and 1 foot on the unethical side simply means you're pissing the middle. Yep. Pretty accurate. Thank you, JPC. Crazy Cat Queen, does the appeal court see all motions, including the summary, the SS motion, or only the trial stuff? Will this affect it at all? You have to do assignments of error, which is basically you say the judge made an improper ruling here, 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 here. And you have to point to the record on all those assignments of error.
Yeah.
This one is going to be a lot. JHACH is going to throw shit at the wall until something sticks. Hi, Rob. What's Mischief Manager's favorite colors? Kurt will like this one. Orange. K-Rab, this is also why parents like Maya get treated the way they do. Dependency court was biased to the institution. It has to stop. That dependency judge was a sub-judge, and I will agree with you in large part here. I think sub-judges, while they have the best intentions, they are not on the bench full-time for a reason. Some do well, some don't. This one I have issues with, big issues with. And I've appeared before several that I have problems with too. M169, do you think it's probable that this firm got so used to the deep pockets of their client, it went to their head? I would say yes. They've been JHACH's shield for a long time. Correct. I don't think there is any fucking way that JHACH had any fucking clue this supplement was filed. There is no way.
I'll agree with you as to that much. But that being the case, it seems impossible that JHACH isn't aware of the general tenor of the case that's been going on this long. So they may not be aware of this specific thing, but I'm guessing from how far counsel has been willing to go that JHACH has not gone to their lawyers and said, hey, you were a little bit far over here.
That shit out.
Yeah. So I think that they endorse it because surely they must be aware of some of it. And apparently they haven't had a problem, or otherwise their attorneys wouldn't be going this far.
Which speaks ill on them, and they should know that.
Yeah.
So, yeah. Gypsy F, do you think the judge's relationship with JHACH's appellate attorney made him biased? I don't, not, no. On the jury instructions, no. And I will point to this last moment, the moment I pointed to several times. When Altenburn goes to Carol and says, so the jury should be presented with one or the other, the greater weight of the evidence or clear and convincing.
Of course you want one or the other because you want to argue the error on appeal the other way. You, of course, want to argue it. It
And
should,
Judge Carroll-
regardless of which they give you, you're going to argue it was error because it should have been the other one.
Yep.
And the
what
judge
does
is like,
Carroll
no, I'm just giving both. And so you're mad.
do? That was the best. It was the best, not slap in the face, but it was saying, no, we're not doing that. Whiskey 77 is someone who lives in the area. I'm just heartbroken. John Drop Kids has allowed such a filing. That's what Kurt was mentioning. And I think that it does go back to them. On a plus side, the privatization on CPS is being spotlighted in the news and the crazy numbers of cases. Yeah, I've got to contact a Pennsylvania controller in the coming weeks because there's apparently an investigation in a hospital up there that I want to take a look at. Privatization and offering incentives to find these things is the wrong way to go. Just saying.
Do you want me to get? Do you want me to get a valid marriage, or to offer the marriage? Do you want me to marry you guys?
You want to be the ceremonial? What if we had you and Ian trade? Like if you gave some of them, Ian gave the other part.
That'd be fun.
It'd be fun. Chris Cat Queen, if our judicial system is so overwhelmed, why are so many motions and hearings allowed? They shouldn't be, but they are granted and entitled to an audience for each motion, which is why they should be sanctioned for filing frivolous ones, to be honest. Whiskey 77, as a Floridian, I'm feeling a bit targeted tonight. Nope, not targeted. Alan Fortenberry, shock, Ron Elias was an alias. Shocker. Alan Fortenberry, did he lie to the NFL or did they hire someone convicted with fraud and put them in charge of their money? Oh, conspiracy. 20th Century Fox, which is worse, welfare fraud or this fraud? Kurt?
All bad. It's all bad.
Every fraud. All fraudery.
It's all bad.
Yellow Pill 17. Didn't Amber Heard's lawyers do this also? They did.
Not to this degree.
Not to this degree. This is Elaine Bredehoff filed a motion and then politely backed off of the motion.
Yeah, because even Elaine had boundaries.
Yeah, this is filing a motion and then doubling down.
Oh.
Triple.
So for whatever can be said for Elaine, she actually has ethical boundaries. That's nice.
More so than the other lawyer. Marissa, thank you for being a member for 11 months. Congratulations. Grassfolk. Correction, NFL fraud guy, Amit Patel, is not the guy fleeing who got 25 years. Nikesh AJ Patel. Different Patels.
Well, they mentioned him in the same article. That was confusing.
Okay. Confused. Chris Cat Queen, even a mechanical, not electric typewriter, you can, quote, cheat the spacing, but you have to dial the roller the same number of clicks for even spacing. Interesting. Yellow Pill 17. I finally remember the judicial smackdown from Ben Chu when AH's lawyer engaged in such fuckery. I want fire and brimstone in the response. That's my opinion. XCDA, it's sure if I should be embarrassed or not. Not sure if I should be embarrassed or not. The double space motions is my favorite. I'm such a nerd. I like double space is not the argument. It's what is double spaced. God. Ian Paler, law firm, Your Honor, we use Lotus Notes. Oh, God. Yeah, give me that. Fantastic. Cynic in Chief, the best part, the point unit varies by country. What is a point? What is it? What is a dot? Okay. Bop it. Oh, be still my nerdy little heart. A case on line spacing. We had it, and you had an expert on line spacing. Ryan YYC Kurt has proposed a CNC IBM selectric typewriter.
Isn't that the one with the really weird ball head where it wasn't individual keys, but it was like a ball that like rotated to? It was that weird. Wasn't that the IBM Selectric?
Wait, I'm looking at it. I'm trying to find it.
Yeah, it had some sort of rotating all the letters were on a ball and it would rotate the ball to hit the thing?
I see the ball.
Yeah.
Oh my gosh.
See, I know my typewriters.
How
Represent.
do you know this?
I'm an educated man.
This electric typewriter. Hang on. This is worth seeing.
Hmm.
Share screen. This one. This?
Mm-hmm. Yeah. So they have little balls that rotate and yeah. Yeah.
Wow.
If you ever see one in action, it's pretty cool the way it does it because it moves the ball very fast and very precisely. It's very cool.
That's really cool.
Yeah.
All right,
And
folks.
you could change the balls to change the font as the chat notes. So yeah.
That's really freaking cool. All right, folks, we are at the end of tonight's live stream. Thank you for being here. Thank you for tuning in. Thank you for having fun with me, Kurt, and Ian. Please go check out Kurt on Civil Law, who is probably the best legal mind I can ever think of when it comes to any Supreme Court argument or constitutional rights. Honestly, he and I have a hell of a lot of fun talking about that kind of stuff. So please check out his channel, especially when he covers anything Supreme Court. If you see Supreme Court and Kurt's covering it, please watch the snark on both sides because he annihilates both sides in their arguments. So please,
Where
go check it out.
appropriate. Where appropriate.
Yep. Ian Runkle, please remember to vote for him and the Gundies. Also, go ahead and buy one of those. Pour one out for the
Oh
Thursday.
yeah, they the chat is mentioning Prototopics has announced on Twitter, which he has in fact announced the new Lawyers and Dragons is coming December 16th at 10 a.m. featuring you in the Wizard of Old Winter, a Lawyer
December
and Dragons
16th.
holiday special.
Okay. December 16th. Tune in. I will apparently be there. I will be there. I go where I'm told. Like, I am very good at following instructions.
Then your wife should have an easy time with you.
Well, it's good because what she'll do is she'll say, call Kurt back. Because I will forget. Like, I will put my phone down, walk away, be in the shop. I haven't called Kurt back. Damn it. I haven't called Kurt back. Kurt is great about calling me to remind me I haven't called him back. And I love talking with him. He and I have, you know, what's funny is some of the best conversations I've ever had have been on those late nights when you get done streaming and I say, give me a call.
We had a good time last time we talked.
Yeah. Yeah. So I love all the friends I've made in this sphere. It's pretty amazing. And you can make really good friends on the internet and have a good time and just enjoy each other's company. So, to all of you who are watching, please go check out Kurt from Uncivil Law. Please go check out Ian Runkle of the Bailey. Please go vote for him and the Gundies. Please support those two channels. It means a lot to me to see my friends do very well, and I do enjoy spending time with them.
We hit 126,000. We're doing nice.
126. God, I love it.
We're growing, and our Twitch presence is actually doing much better than I expected, which is nice.
I don't know Twitch. I don't know computers. I don't know Twitch. I'm gonna be educated in this forum. I will at some point in time. But without further ado, we're gonna wrap for this evening. Thank you all for being here. I very much appreciate you guys catching the coverage. I will catch you guys next week at some point in time. I'm not sure when. I'm not sure what we're talking about, but I will be there. To all of you that are watching, please enjoy your weekend. Enjoy the holiday season. Get out there. Go make something. You will feel better. And I will go ahead and roll the thing that I made that one of the things I make in the shop that gives me a little bit more happiness on a day-to-day basis. So cheers. Good night. Love you all. Wish you a pleasant weekend, and we'll catch you next time.